Yes, unfortunately, we are a little behind. We were right in the middle of our a discussion on bankruptcy clarification. Mr. Bishop, please, if you'd like to resume your post at the podium. Is Joe Clarissa or David he is on? Okay, fantastic. So I think we're gonna be up to speed here. We left off, we're talking about some of these amendments. Mr. Ravel, do you want to pick it back up?
Thank you, Mr. Chairman. I think one thing I think as a working group that we'd like to clarify here is that there's no intention to try to undo the good work of anything that was done earlier, particularly with regards to speedy legislation or regulation. And what we're attempting to avoid is any lack of clarity over what happens to a customer's assets in the event of bankruptcy of a financial institution, and that's it. That is I think the sole purpose of this. And so I think there are different bits of wording that we've got from different people on the working group that we just need to bring together as a working group. How we then go forward that's your fastball. But we can, I think as a working group, we can bring that language together.
So, Mr. Ravel, kind of my sense is, I kind of listening to the testimony this morning, it might be better if we don't take any action on this particular bill or this topic right now, because I think given what Joe has said about our previous measures and additional stuff regarding the nodes and staking and that kind of stuff, it might be worthwhile to just not take action on it right now. Let the working group continue to kind of button it up over the next several months, and then we come back in November, and then we can have a more refined product to discuss at the committee. I mean, that's my thought, and absent any objections, I think that should probably be our course of action on this. And Mr. Co-Chairman, do you have any?
And Mr. Chairman, I think that's the right approach. That will mean that we won't be able to have the Minerals Committee sponsor it, but I think it's prudent for us to do it this way because we need to make sure that we take the time to involve the commissioner, stakeholders, and get the language right and ensure that everyone has a chance to vet it, then have it come back to the committee, make sure that we're comfortable vetting it. And so perhaps the next meeting, we end up just getting to the point where we have a motion in support of it, and then it ends up being an individual sponsorship because we won't be able to actually sponsor it as a select committee. I think that's a prudent approach so that we get it right, which is more important than getting it fast.
Mr. Co-Chair, I think that absolutely is right. I mean, I know, and for the folks who are just tuning in right now, the way that these bills work is if we are amending any of our banking statutes, it has to go through our Minerals Committee, which is another standing committee to which Mr. Bishop reports, and just the timing of our meetings, it's just not feasible for us to do it. So that's kind of why we're taking that approach. Mr. Bishop, are you fine with staying engaged with the working group over the next several months?
Yes, Mr. Chairman, thank you. Yeah, I'm definitely okay with that. And I think it's better to put some time into it first.
Perfect. All right. Absent, or Mr. Ravel.
I did have one question on that, which is that some of the language is not amending our existing, or if I could be mistaken on that. Is all of the language here, would it technically require minerals? Or is there only elements of it?
I mean, if you look at it,
Mr. Chairman, anything that goes into Title 13 would require Minerals Committee, and I believe everything is in Title 13.
Yeah, I'm checking right now.
They're
It's
mostly,
all Title 13.
looks like mostly.
Okay.
Well, there's one that's in Title 34, but
Gotcha.
Yeah, understood. Mr. Chairman, if I might too, I just, if
Go for it.
it's all right, just to check with the working group, Mr. Evans has been patiently waiting. I just want to make sure he didn't have any comments before we move on from the topic too. Thank you.
Mr. Evans, are you still with us? And if so, what are your thoughts?
I am. Thank you, Mr. Commissioner. I have no further thoughts. I think that getting it right is important. And so if it's to get all the language together and put it before you when it's ready, then that's what we should do.
Well, absent any objection, outstanding. And with just like that, we are almost back on schedule, 20 minutes behind, but that's okay. Mr. Bishop, thank you very much. Up next, we have our fine Secretary of State, Mr. Gray. Oh, That's absolutely right. Of course, getting ahead of myself here. Is there anybody in the room that would like to do any public comment on our bankruptcy clarification bill? Please go ahead. Come forward, state your name and who you're with, please.
Thank you, Mr. Chair. Good afternoon, Lisa Jurdy Spillman. I'm here as a director of SAFE, which is an entity of SFOX. SFOX is a Wyoming regulated, SAFE is a Wyoming regulated trust company. And we not only custody digital assets, we also trade and stake and provide prime services. And the concern that we have with this particular bill falls within the definition change of custody services. So under the trust law, a trust company can obviously exercise discretionary services. Under the digital asset law change, it eliminates that language to provide discretionary services. So it potentially has the negative consequence of creating this unintended consequence of really kind of tying companies like ours up in a knot potentially. So we'd like that either struck or some sort of additional language put in. Line 6.
Yeah.
That might, or Mr. Kaufman, go for it.
Mr. Chairman, I was just going to chime in, and I've had conversations with the commissioner and some others about this, but I tend to agree with this point. I coming at it from an SBDI standpoint, and let me put on the record, I'm fully in support of this bill and what we're trying to do, and I think the idea is spot on. But I do think that the working group could probably refine this language a little bit more and come back, because I do know from being on the working group that wasn't an intent. And now that we've heard some of this comment, and quite frankly, I share a little bit of the concern as well. So I think that's another one of those issues that we could certainly address in the working group.
Mr. Bell, go for it.
Just to concur and clarify, that is not the intention. So if that's what the language inadvertently did, we'll clean that up.
So I think that's a valid point, and thank you, Ms. Spielman, for bringing that up. If you wouldn't mind, given that we're going to carry this forward and refine it throughout the working group, would you mind emailing your comments to the committee? And so we can, when the working group reconvenes, this could be one of the things that maybe we wordsmith and try to make sure it does what we intended to, but don't create any collateral issues for folks like yourself. Is that acceptable?
Mr. Chairman, absolutely.
Thank you.
Thank you.
Mr. Co-Chair, are any other questions
Yeah.
for Ms. Spielman?
Mr. Chairman,
Or Ms. Spielman, we're not quite done with you.
sorry. Thank you, Mr. Chairman. I guess I just asked the working group to think that through on the substantial discretion aspect. And it was my understanding that SAFE is providing custodial services where you believe you are exercising substantial discretion, and therefore you see this language as excluding you. Is that accurate?
Well, under the
Ms.
way.
Spielman, go for it.
Oh,
Please.
thank you. Excuse me, Chairman. Mr. Chairman, co-chairman, under the Wyoming trust law, we are, any trust company can exercise discretionary powers over assets. And this language in the digital asset law says that the companies can carry out custody services as provided in this act. And it used to, the existing language allowed the discretionary acts, and this language takes it out. So it kind of calls into question the ability of a trust company that manages digital assets to continue to exercise discretion.
Discretion. Okay. All right. Thanks. Yeah.
Mr.
Sounds
Cervell.
like we can just work on that. Go ahead.
Thank you, Mr. Chairman. And just to one thing that is taking place in this new language is that we're delineating between a custodial account and a fiduciary account, and creating terminology which I believe is consistent with what you would typically see in industry. And Joe can opine on, Mr. Evans can opine on if this is consistent with what language you would use in bankruptcy proceedings. But the idea is that a custodial account is one where there is not an exercise of substantial discretion. And a fiduciary account is one where there is, both of which are contained in our definition of a trust relationship or a trust agreement with a customer. By delineating a custodial account as one which does not have discretion does not mean that it's being excluded from this trust relationship. There's just two different subparts. It can either be custodial or not exercising control, or fiduciary where you are exercising control. And Mr. Evans may want to weigh in here if I've said something that's not consistent with his understanding.
Mr. Evans?
Thank you, Mr. Commissioner. I think the only clarification is that that distinction, Joel, is in the new draft, not the one before us. There's a trust account, and then underneath it is a custodial account and a fiduciary account. But I agree that the intention was not to exclude anything that the speedies or the trust could do with respect to their discretion or fiduciary activities. It was just to identify them more clearly. So if there was a bankruptcy proceeding, it will be clear that it was contained under the umbrella trust account and the customer's assets were protected.
And that was my understanding as well. Was that the intent of the language change to some degree was to provide clarity between custodial and fiduciary services and make that a little bit brighter line, but both can be trust services and it's just whether or not you're taking fiduciary responsibility. So I'd ask that as we work through this, that we make sure that we're assuaging your concerns and that we're not overlooking something. I see Mr. Kaufman has a
Yeah,
bit to chime in.
or sure, go ahead, Mr.
Yeah, Mr. Chairman, I just want to clarify, because again, I'm in agreement with all of the comments, but just to point out the importance here, because all of the changes that we were contemplating under Title 13 with respect to the banking and trust, right, activities, this particular change that Ms. Bone raised the concern on, which I share, is in Title 34, right, which has some different implications. And I can attest that a lot of the SBDIs in particular have sort of developed and built product and service offerings around that definition. So again, I'm in agreement with the concept. I just think we need to revisit that language a little more closely.
Yeah, Mr. Kaufman, I would largely agree because Title 34 is our property law title. And so I guess, and that just needs to be can we create a carve out or some other type of mechanism moving forward while also not amending, leaving this the way it is? I think that might be one of the key questions our working group has to work through. We'll definitely make sure to take this into consideration as our working group convenes, because I agree. Adjusting our property law, that's not to be taken lightly. It needs to be thought through thoroughly. Thank you very much, Ms. Phelan. Appreciate your testimony.
Thank you, Mr. Chairman, co-chairman.
Any other public comment in the room? What about in the Zoom world? Clarissa?
Oh, he's in.
Oh, Brendan. Oh, actually, real quick, Brendan, hang on. We got one in person and then we'll let you go for it. Please sit down.
Make this quick. My name is John Stokes. This is a personal reflection. Just be careful not to become kingmakers and not, craft laws that are duplicitous or redundant. Redundancy should exist in the code and the systems we build, not in the laws. And redundant laws could potentially, create unfair competitive advantages, which leads to regulatory capture, causes a lot of confusion and complexity, legal challenges, erosion of trust, potential conflict of interest, barriers to entry. So let's keep those in mind when crafting these laws. Thank you.
Thank you very much. Well, Mr. Stokes, hang on a sec. Committee, any questions for Mr. Stokes? We appreciate you being here. This is like the third or fourth year I've seen you here. So thanks for keep coming back.
Good.
Looking forward to it. Sorry, Brendan, please go ahead. Mr. Maher, again, we know who you are, but you know the drill.
Sure. Can everybody hear me?
Yes, we can.
Great. Co-chairs Rothfuss and Western and committee. I'll keep it brief, particularly that you're going to look into amending what we have here in November. I wanted to speak to two things. First off, just to stay with protocol, my name is Brendan Marr. I'm an MIT Media Laboratory alumnus from 1998. I'm on the committees for digital assets and digital identities and DAOs. There are two things I want to briefly mention, and it has to do with one, commingling of assets, and two, a footnote on a related topic of trusts, which are data trusts. So first, I will speak towards the commingling of accounts. I urge the committee to look towards some of the legislation that Wyoming has already passed. The Series LLC has some great language on the commingling of assets. And the Series LLC, as you probably all are aware, but others may not know, has been used extensively in the financial industry to deal with series of assets and funds. So there's quite a bit of language there that might be useful. And lo and behold, part of that wording is that the parent LLC may hold assets directly or indirectly, including in the name of the series or in the name of, in this case, the limited liability company. All of this becomes very, very important because as we work towards other things, which brings me to the second topic, which is a data trust, you'll see how all this stuff works together. But I will pause for a quick second to take any questions.
Committee members, any questions for Mr. Maher? And I don't see any. Please proceed.
Yes, the related topic is data trust. What we're doing here is extraordinarily important. And at a certain point, I just want to put the bee in everybody's bonnet that related to all of this kind of trust will be the need for a data trust, something that allows for a trust of data and how that data is used. And, you know, given everything that's happening over this last year with artificial intelligence, it's very, very clear that, you know, this is a tremendous opportunity for Wyoming to do something that no other jurisdiction is able to do. So we'll talk more about that, but I can see the torch. I hope that's helpful.
Thank you, Mr. Maher. Appreciate that. Any questions, committee? Seeing none, Mr. Maher, thank you very much for your testimony. We always appreciate it. Seeing as we're done with public testimony for topic number 4, let's go ahead and move on to lunch now.
Fine.
Up next is our Secretary of State, Mr. Gray. Thank you so much for making some time to come and chat with us.
Yes. Thank you. Thank you, Chairman Western, Chairman Rothfuss, the entire committee. Just to introduce everybody for the record, I'm the Wyoming Secretary of State. Chuck Gray to my right is our business director, Colin Crossman. And then to my left is our general counsel and also our policy director, Joe Rubino. We're going to start off here pursuant to the agenda with the Digital Asset Registration Act and Corporate Filing System updates. So Mr. Crossman is going to talk about our rulemaking to carry out Senate File 76, which was Senate Enrolled Act 95.
Please go ahead.
Thank you, Mr. Chairman. Colin Crossman, Director of the Business Division. Before I get into digital asset registration, I just want to have some throat clearing about some of the stats that that this position usually provides. I know that you like to hear about Series LLC registrations. Back in April, I said that there were 979 active. Today, there are 1,059, so about 75 or so increase. Of the Series LLCs. And in DAOs, back in April, there were 518, and now we have 524. So not a lot of DAOs that have been, but well, I guess we had about 7 dissolve. So, you know, the froth is there, but it increased a little bit. That is in comparison to our overall business filing growth, which is up 27.62%, which is a number that I announced in the Corporations Committee a couple weeks ago, with a total filings of 590,000 for the fiscal year ending 23. Quite a lot. So.
Very
Okay.
impressive.
Yeah. All right, digital asset registration. As you know, Senate File 76 was passed earlier this year, and it creates a system where people can register digital assets in the state of Wyoming. It left a lot of things unsaid as to precisely how we would take care of this process, and had us filling in a lot of holes into, how we would handle filing it, how we would take in the information, how we would check on things. So we entered formal rulemaking, I believe at the end of July. And so we have, the rules are out there. I went through and we basically clarified certain things. One of the problems with a digital asset registration in general, not with this act, but the concept of a digital asset registry in general, is what is a digital asset? It's a very broad term. You can say, okay, is it an asset on Ethereum? Is it an asset on Bitcoin? Is it an asset on one of these other main chains? All of them have different characteristics. All of them have different things. So we had to write a set of rules that attempted to classify and capture any kind of digital asset that someone wanted to bring to us and allow it to be registered. I think we did a very good job of going down that road. It does require so a digital asset that cannot generate a cryptographic signature by statute can't be registered. So that is one of the basic requirements. But we define in there precisely how an asset is to prove itself out, how it generates its cryptographic signature, and what we take for that. And moving on, how we take it in and then provide the certificate. So and another aspect that we have to deal with is, as I said, the main chains can differ, but even on a specific main chain, there are many technologies. Ethereum, for instance, has at least, well, 3 that I listed inside the rules, ERC20, ERC 721, and ERC 1155. I know there are others. Right as we were writing these rules, Bitcoin came up with this thing called ordinal inscriptions, which is very new. So we had to make sure that kind of those kinds of technologies are not only captured as of today, but the regulations are flexible enough to capture them in the future without having to go through another formal rulemaking and or going back to the legislature to ask for new statutory authority just to capture somebody's new dog token. So I can stand for questions on that now if you like.
Committee, any questions for Mr. Crossman? Mr. Co-Chair or Mr. Pope? We'll come back to you, Mr. Co-Chair.
Thank you. And we appreciate the work that you put into this in making it broad spectrum, trying to be inclusive of technologies. Will we have the capacity to authenticate cryptographically the registration as well, or are we planning on authenticating like through certificate, or what will the Wyoming side look like? And again, I was anticipating there'd be some sort of like cryptographic testimony towards it, but I realized that that's a bit of a challenge there. So I'm curious what Wyoming will provide. I've registered my digital asset with the state of Wyoming. What is the attestation to that registration?
Okay.
Mr. Crossman?
Thank you, Mr. Chairman. So maybe a little bit of an example of the flow of a registration would be instructive here. So first of all, the statute requires that the registrations be digital. And well, actually, I don't believe the statute actually requires that. We specify in the rules that the registrations must be digital. We will not take paper registrations because it's a digital asset. Yeah. So we
Makes sense.
Yeah, we're establishing a new wizard through the WYO Suite portal, so that people will go in, they will have a series of questions they have to answer that follow the statutory requirements. One of them being that the registrant, not the applicant, but the registrant must be a Wyoming individual, either natural person or entity. Not the same as a CRA, but similar. That person will then fill out the fields, which is, we're talking about, they have to define the asset and describe it in detail. They have to provide the location of the asset on whatever chain or whatever substrate the asset is located on, in a mode that is customary to people on that chain. That's about as close as we can get, because we have no idea what new chains might require, how they might do it. I can't specify, like, for instance, with ordinal inscriptions on Bitcoin, you could provide an XPub. To my understanding, Ethereum doesn't have the concept of an XPub. They don't use multiple, they're an account-based system, not a UTXO-based system. So the concept is semi-meaningless over there, at least to my understanding. So how we get that information, the person has to they have to know what that is and have to input it. And so then they have to input the location of the asset on that substrate. And from there, we will generate for them the unique identifier, a timestamp, and a couple of other pieces of information that they will then take to their system, their wallet, their whatever, cryptographically sign, send back to us. We will all countersign, and then they will receive a certificate that has a signed, countersigned cryptographic signature that we then provide the raw text. So if you have the raw text and you have the two signatures, you can prove out that it was signed by those two keys.
Good.
Fantastic, Mr. Crossman. Real quick, so you're talking about just the type of chain, you're talking about type of validation as well, that they come to you and say, I can validate this on chain. Is my understanding correct there?
Mr. Chairman, I believe, if I understand the question correctly, yes. So different chains have different types of cryptography and different types of different methods of proving out various things. Ethereum and its derivatives using MetaMask, there's an easy way to sign a message. Bitcoin has a similar easy way. It's a different similar easy way, but there's a way of doing it. Other chains, I imagine, have analogous systems. So you have to be able to, if your chain can't do that, then unfortunately you wouldn't be able to register with us. But there are ways of making that happen. So,
thank you, Mr. Revelle.
Yeah, thank you, Mr. Chairman. Mr. Crossman, first of all, thank you for your work, large task. We had a conversation that you were a part of, I believe, in the last committee meeting about the idea of a lien registry, which I think may be an interesting idea to build upon this, and an opportunity for the state to generate substantial revenue if it works. Is there anything that is missing or that we can build differently if this is a step toward ultimately being able to add a lien registry?
Mr. Crossman.
Mr. Chairman, as it stands, this system, the way you would have this be a lien registry is by once you've registered the asset, it now is a known asset. And it has a marker and a distinguishing characteristic, and the fact that you are now under Wyoming, it's domestic. The asset has become domesticated to the state. You've availed yourself of the use of our laws, and specifically the use of the Chancery Court. If you then filed a UCC against that, I believe that would be functional. But I mean, I guess we would call that a kind of a hacky way of doing it, but if you wanted to put an additional layer of specific lien on these assets, it would require the building out of an additional system to tie that lien to these assets in our system in a non-UCC kind of way. So if you're talking about a non-UCC lien filing, then that could be built out and that would be interesting. But I think that just the establishment of a registered asset here would allow an entity to avail themselves of the standard UCC system. It just wouldn't be, I mean, it would be the old school UCC system.
Mr. Bell, follow up.
Thank you, Mr. Chairman. I have no further questions.
Senator Heather Khan. Mr. Co-Chairman.
I'm good now. No further questions. Mr. Pope was putting-
Yeah, that's right. Mr. Pope, circle back to you.
Thank you, Mr. Chair. Slightly off topic, but thank you for the statistics you put together. Does the Secretary of State's office believe that the implementation of the Corporate Transparency Act will affect state filings and any of the work that you guys have, the great work that you guys have done?
Mr. Crossman.
Mr. Chairman, the Corporate Transparency Act is a very, very big topic. We got into it. We got into it at the last meeting, and you weren't on the board yet. But bluntly, yes, I think that the Corporate Transparency Act will affect filings. I think they will go down a little bit. I don't know. Well, okay. I'll clarify that and say, I don't know what it will do to the filings as an absolute number. I believe it will reduce slightly our speed of growth, which is substantial. Wyoming is right now second to Delaware, and we're the third best place in the country to form your business, with the first being whatever state you currently live in. So, and then Delaware, and then us. We've passed Nevada, partly because we are, in my opinion, more business friendly than Nevada, but also because we are one of the cheapest. So will the Corporate Transparency Act affect filings? Absolutely. Will it will that mean that that's a noticeable impact on our growth? That I can't speculate to. The Corporate Transparency Act, unlike what a lot of people seem to think, does not put any onus on the state of Wyoming. It does put one tiny piece on us. However, the feds haven't funded that piece, so whatever. The feds have requested that we provide information to new filers. Of course, we will do this because it's in the best interest of our citizens that we tell them what the feds are doing. We've looked at what Alaska's put together, and it's a nice comprehensive one-pager for new filings. But as to the impact on Wyoming and what we need to do, there is almost nothing that we need to do to implement the Corporate Transparency Act, other than our newly formed corporations starting after the 1st of January of next year, within, I think, 60 days, filing a document with FinCEN on a website that, to my understanding, has not yet been built out for a fee that has not yet been specified.
Oh, follow up. Just thank you very much. I appreciate that.
Oh, I have a follow-up, if that's okay.
Mr. Crossman. Go for it.
There is active litigation against the Corporate Transparency Act, I believe, in the District of Alabama. And I checked Pacer yesterday, and there hadn't been any updates for several months. There's a pending motion to dismiss, but I think that motion to dismiss was filed in March, and the judge has yet to rule. I don't know. I don't particularly like to read tea leaves of federal judges, but as it does seem like that's a fairly long time to wait to actually dismiss something. But I think that that litigation, which is not yet joined by any states, I might add, it could potentially change the implementation of the CTA by putting a stay in place if that were to come to pass. There are also at least 2 bills pending in the federal legislature to delay the implementation because of its widely believed negative impacts on small business.
Thank you, Mr. Crossman. Mr. Pope, was there follow-up? No follow-up. Might jump in real quick. Mr. Crossman, if assuming my understanding is correct, that the Corporate Transparency Act, which I certainly think is a gross violation of privacy, it does forbid you tokenization for some types of entities. Is that correct?
Mr. Chairman, it does not forbid tokenization explicitly. It, however, makes tokenization exceedingly difficult because one of the concepts of tokenization is that, well, the tokens are bearer assets and they make bearer assets effectively illegal. So while it doesn't say tokenization is illegal, it does make bearer assets illegal. This is one of the things that it does, and I believe I brought this up at the last meeting. It does make, or it does admonish states from creating a bearer assets, and tokens being bearer assets would be covered by that implicitly. So there is that problem. You can convert tokens into non-bearer assets if they are fully registered and fully transparent. But now you've just made shares, which are.
Mr. Co-Chair.
On that line, though, it seems that another potential workaround would be, and this is something that we've been aspiring to for quite a while. If we had a corporate filing system which was authoritative on chain, something along those lines, and updates could be authoritative, cryptographically signed by the state when I make a change. And maybe I'm incorrect, but with the Corporate Transparency Act, if you were to immediately say who owns it at any given time, it stops being a bearer and object, and it starts being more like a share that we're talking about as some type of security. So I think that's compliant. Maybe it's not, but I think that would be compliant. So if it were simply that any transaction related to change in company ownership that was registered in Wyoming had an immediacy to it, where once it was countersigned by the state of Wyoming, that information was immediately sent to FinCEN. I feel like that might be compliant.
Mr. Chairman, that's a big, that would be a big undertaking. That aside, I'd have to really look into the act and see. Sure. But my gut is that because of the flow of information in the CTA being from the entity to the FinCEN, if Wyoming were to build this out, I don't know if that would be, we may be able to call that a assistance of compliance, but it would not necessarily guarantee compliance since the onus is on the entity itself and not the state. That's how the feds have avoided some serious constitutional problems, at least in terms of state action. That aside, that I would have some reservations on a system like that and its implications on privacy as well. As you know, the Corporate Transparency Act what it requires is the disclosure of ultimate beneficial ownership, and the phrasing and the what they have defined as ultimate beneficial ownership in the Corporate Transparency Act is rather broad, in that it includes a handshake agreement between two individuals. So if you and I have an agreement where I own the shares, but you tell me what to do and how to vote, even though you have, if one of us were to pass away, you would have no rights to those shares. They would go through me. That technically would qualify for full disclosure under the CTA. There's a lot of nuance there that people I don't think have fully sussed out, and it's pretty extreme.
There's certainly more where that came from. Members, any additional questions for Mr. Crossman? Mr. Adele, please.
Thank you, Mr. Chair. I want, if I might, Mr. Crossman wanted to go back to the prior question about the lien registry. And I just, Mr. Kaufman helped me understand a little bit. I'm not a legal expert, so when we're talking about UCC and items like that, I'm a little out of my depth, but So if someone wants to file a claim on a digital asset today, they do so by a manual process with your office. Is that correct? That there's a manual process by which someone can file a claim against an asset?
Mr. Crossman.
Yes, Mr. Chairman. Yes. So the UCC filing, it's manual. There's a digital way of doing it, but it is effectively, you can file a UCC is a generic security interest in any asset. It can be an interest in a bank account. It can be an interest in a car. It can be basically everything except real estate. And I think even real estate can be done with a UCC in certain cases. But yes, it's any recognized asset can be covered by a UCC, but it is fundamentally a manual process or through a website portal. Yeah.
Mr. I'll follow up.
Yes, thank you, Mr. Chairman. Then if the next logical step for the digital asset registry is to have a digital asset lien registry, we'll have one that is digital and one that is manual. And there's going to need to be either a manual bridge burden, which falls upon your office, or is there something different that we should contemplate today? Our committee should contemplate to make that transition easier should that happen down the road.
Mr. Crossman.
Yeah, Mr. Chairman. I don't know if there would necessarily need to be a manual conversion in that case. If you created an entirely digital lien, a special registry just for liens over these types of assets, and it was computationally based, and in the statute you linked it with UCC. I mean, it would be a non-UCC compliant filing, and it would not necessarily be recognized as a UCC filing in other states because it would not be compliant, but you could effectively generate it so that it is UCC recognized, or all the UCC law follows from that here in Wyoming in the Chancery Court. I'm not sure if that's a great idea, but this is something that definitely could be thoroughly studied, because it once these things are registered as assets, people are going to want to pledge them as security for debt. And so some method of making sure that the security interest is properly perfected, such that, as you were talking earlier, in a bankruptcy proceeding, the bankruptcy court gives it full credit. That would be, I think, necessary. And any method done needs to make sure that happens right. But I don't think I want to speak off the cuff and say, yes, that's totally doable. But I don't think that would be something that would be a necessarily downside.
Mr. Bell. Mr. Kaufman.
I guess I would, Mr. Chairman, thank you. Just a question for the committee, which is, or the legal experts on the committee here, that I think that the big use case that emanates from this registry is a lien registry, at least in terms of a revenue opportunity for the state, and something that is really groundbreaking. As Mr. Crossman just stated, that once these assets are registered, the folks are going to want to pledge them and use them in the capital markets. And there is not currently a solution for that. And would we be wise to contemplate that next step and allow for a more seamless digital asset lien registry to be built on top of this digital asset registry?
Mr. Vella, I certainly think that what you're saying totally makes sense. That it's only a natural next step to collateralize these. I do think we're kind of getting right back in the discussion we had last time, which was that there's assuming I recall correctly, that there was just a lot of concerns about congruency between, Article 12 of the UCC and that type of mechanism. I do think that'd be a pretty serious undertaking for us to do right now. I guess at the end of the day, if the committee so chooses, that's our collective discretion. But that was my, please you correct me, but my recollection from the last meeting was that there was just that. How do we make this congruent across all platforms, across DCC, across the registry? My recollection was that it was too much to handle right now. Mr. Co-Chair, do you want to weigh in?
Yeah, and I think we were waiting for this to be built out a little bit further before we understood how it would work. I do see this as a important next step. And one of the things I was going to ask was what the timeline looks like for full operation of this, and then contemplating, all right, well, what would it take thereafter to build a lien registry and what resources would be needed? This would be stepwise. At the same time, the broader UCC filing and corporate filing, authoritative registry, API driven, like we've talked about, was another point on the agenda. So I think this is a step towards a larger system that will make, Wyoming the go-to destination for any of these types of digital asset related filings, or just anybody that's got the wherewithal. So I don't know how much legislation we need at this point in time to even accomplish that. I think we need to keep moving down this path and then see as we get towards the session, if there needs to be an additional appropriation to move that along. But we can try and explore that. Getting to, do we need to change statute for that? I don't know that we do. If we've just gotten electronic, if we've got a lien filing registry, I mean, maybe that does require some statutory changes. It's something that we've talked a little bit about. You think so? Okay.
Mr. Co-Chair.
Yeah.
I think just given the exceptionally litigious nature of just perfection of security interests and all that kind of stuff, I think this is something that I think there's a lot of value there. Absolutely. And I think, it's only just a logical step in a lot of senses, but yeah, I think we're about to climb a big mountain there. That I think that might be a really good topic for our next interim with plenty of working group input, but I think we just might be biting off a little bit too much at this time.
Well, I think it's important to start that discussion then and see, when we have everything that we've passed related to digital records, UITA, digital assets, how it's related under the UCC, I guess I'm struggling to understand how you couldn't file a lien against a digital asset, even if there wasn't a good mechanism for it. I feel like there would be statutory legality because you can file a lien against property. We've characterized exactly how digital assets are treated as property under Wyoming statute. I would expect you to be able to file a lien legally in Wyoming against digital asset. I just don't quite know how that would be recorded necessarily, but could you not do that? Does anyone see a challenge to why you could or couldn't do that? I might be missing something. I'm not sure.
And is that process adequate as it is
Yeah,
right now?
so the process side is what I'm saying. I don't know that we need a statutory change for the process side. I'm just thinking through, do we have the legal and statutory structure in place to do it? I feel like the answer might be yes. But if it isn't yes, that's really important to know.
Yeah, if the answer is
Because we'll need
no,
to fix it.
correct.
Yeah, Mr. Chairman, I was just going to jump in and make a comment because I agree with you. I mean, yes, I personally don't see anything currently that would foreclose anyone from being able to take their, whatever appropriate security perfection steps they want to take in Wyoming. But I think what maybe you're, getting at is our conversation a couple of years ago about the programmatic creation of entities, right? And potentially building an API-like filing system where, right, we could just blow up the number of business entity filings. And along with that, I think we're also kind of talking about the UCC filings and making that more accessible from folks out of state to make Wyoming a chosen domicile for those. So to me, it's kind of all one and the same, and we're sort of overlapping. And I know we've talked ad nauseum about creating some sort of an API or a different filing system, which is a big lift. But I don't know if that helps, but to me, we kind of need to keep that in mind, because if we're going to go down that road, to me, we might as well take a run at the whole thing.
Mr. Co-Chair, Mr. Governor, and I wholeheartedly agree. I think the glue of this whole, the whole situation would be that type of very seamless, highly capable API system. Because a lot of the actors and parties who are interested in this kind of stuff that's the kind of platforms that they want to be able to interact with and have it be very seamless and effective and quick. And I think, as you say, we've talked ad nauseum about what an undertaking that would be for the legislature, certainly for the secretary's office. Yeah, that's a lot to bite off. Mr. Co-Chair.
Well,
Very
Mr. Chairman,
well, very
I'd
pensive.
just say, that there are two key things to contemplate. One is, are there any statutory prohibitions or any statutory changes that would need to be in place for us to achieve this type of an objective, whether that's the digital asset lien registry or anything else, or whether we're clean there. And then comes the resources side of having sufficient resources to carry it out, which is a separate discussion. We need to be able to address both of them. So I don't know that we're prepared to find out all those details today, but those will certainly be part of that follow-up discussion where we're contemplating this type of build out. So we can ask Mr. Crossman if he has any initial ideas on what that might entail for the build out, but I'm suspecting there might be some more required follow-up on it, would be my guess.
Before we go to you, Mr. Crossman, I think Mr. Vell, you wanted to jump back in.
Actually, thank you, Mr. Chairman. I would welcome to hear the answer to Co-Chairman Roth's question first.
Mr. Crossman, please go ahead.
Mr. Chairman, as I guess it's two components. One, can we do it today? I think we can. I think that at least once the digital asset registry goes live, which, as you may recall from the statute, it needs to go live on December 1st. And at the moment, we are fully capable of taking of that without any problems. Once you have a registered asset, you have a marker that is known now to the state of Wyoming. You have sworn statements or at least attested statements to the location of the asset, and it's they're creating the cryptographic signature that defines the asset. So you could then take that asset's registration number and put it into a UCC filing. Yes, that is a standard or old school UCC filing that's done on paper or on the web, but that should classify its property. It's in Wyoming as property. We recognize as such. UCC covers any property. Therefore, I don't see why that wouldn't function. Is it the most efficient? Is it doing all of the things that a full-on digital asset lien registry would do? Maybe not. But the moment this goes live, I think that security interests can be perfected through that mechanism today. As to making that system more computationally direct, should I get into? Well, we have we testified in front of the Corporations Committee about how we are working on and we have put it in our budget for the SOS Enterprise, which is the next generation of the current filing system we have now. And I believe a lot of those questions would be answered by that system. And one of the concerns that we have is that our growth is so much that we need some sort of a system like that to deal with the growth.
Mr. Chairman, quick follow-up.
Mr. Co-Chairman.
So this is an area where this select committee and the task force before it has a lot of interests and really spent all the intervening years, 5+ years, trying to support the building and implementation of that system. There is a tremendous amount of interest in having cryptographic signatures associated with any build out, an API driven mechanism. There were partners stepping up. There were completed systems that were nearly turnkey that were offered because they wanted to be proof of practice. So there's an awful lot of history to this through this select committee that we'd be happy to share and try and build those connections, because I think a lot of the work is honestly already done and there are willing partners out there that would like to see it done very quickly. The key capacity, the interest case that we have would be ensuring compliance with Web3 transactions, where you have an authoritative state entity which will vouch for the existence cryptographically of a corporation, for example. So this is a real company. It is really registered in Wyoming. We authenticate that. And then that could be integrated into transactions through smart contracts or other automated processes. That's sort of the aspiration. And as obviously then you've got some authoritative testimony as well for, yes, this is a legitimate wallet address, for example, for a company that is a public destination. So you can have some confidence in it. Building up that confidence side of it is something we've been very interested in. And again, we can probably link you to some prior testimony about the global enthusiasm for such a system. I'm confident that if it were built out in that way where it were fully Web3 compliant, you've seen a 27%-ish increase in the last year. I suspect it would go substantially higher than that based on the ease of use. And again, other states have looked at this, right? First to market will matter on this. Other states have looked at it. There was a state along the East Coast that was a long ways down that path and then had an administration change and lost interest. Otherwise, it'd probably be out there already. But it's certainly a good opportunity for first mover advantage for the state of Wyoming to have a full build out. And this committee's been anxiously awaiting that. It's a great piece, not just for what we're doing with digital asset registration, lien filing, but really to enable a broader range of business operations in the state. So hopefully we can stay apprised of what's going on with that effort.
Wouldn't you agree?
We'll defer to my secretary on that. Now, one of the underpinnings, Mr. Chairman, for any new system is the current system. The vast majority of filings are done in paper, and so before we can consider an API, before we can consider any other computational increase, we have to have a system that is capable of handling non-paper filings. And so that is the sort of most important step that we are looking at right now, partly because once you move away from the physical paper filings, or a large chunk of them being required, that changes the load calculus on the staff by a tremendous amount. And so being able to, the fact that we can handle the number of filings that we have now with the current staff that we have is amazing. But if we continue this growth the way we have without changing the filing system, we're going to need a lot more people. If we change the filing system and we get a 10 or 100x throughput factor, then we can continue that growth. And so the changing of the substrate will allow for other things to be considered in a future date.
Mr. Chairman.
Please go ahead.
Can I add a little bit? Joe Rubino, I'm the policy director for the Secretary of State's office. If I could just add on 2 quick notes to that. I mean, of course, that's a policy decision for the committee and the legislature. And the Secretary of State's office will implement whatever legislation is ultimately passed. I think, there's 2 things I would note on that. One that has been talked about, throughout the last interim with these sort of conversations, this is the return on investment for, wholesale adopting an entirely new system. I think one of the things with digital asset registration, and potentially if the committee and the legislature looks into a digital asset lien registry, is, well, we have sort of these legislative adoptions that are going down a route, and they're offering this cryptographic option, this cryptographic filing option, and that it takes an appropriation. There was an appropriation that we worked with the committee on through the last session. It takes investment and proving out sort of the filings. What sort of appetite is there? Is this going to be a boon for the state of Wyoming? Is that ROI there? That's going to be the next question. And so I think to your point, what you said, a few speakers ago, I think that is really, something that could be looked at from a policy perspective. Is what is going to be the appetite for this? Is it going to be non-fungible tokens? Are there going to be people that, go crazy with something that the legislature has not fully contemplated yet? So those are always questions that are out there, but those are sort of the questions that we have. What Mr. Crossman was just getting at, and it sort of goes hand in hand with the return on investment, is the secretary's made clear, this is and we've always been oriented toward, Wyoming-based customer service. And we do have lots of LLCs in the state of Wyoming and out with our exponential filings that love to file via paper. They love to file their amendments via paper. And so that's sort of those are the two things that I think we grapple with. Of course, those are policy questions for the committee and the legislature, but I just wanted to add those two quick notes.
Thank you, Mr. Rubino. Mr. Kaufman?
Yeah, thank you, Mr. Chairman. I just wanted to piggyback off of those comments and maybe get some clarity for myself from the committee and what we're thinking, because again, I'm just sort of reframing this discussion from my perspective. What we saw as an opportunity to Mr. Rubino's point, I mean, we originally kind of approached the idea of the API and a blockchain-based filing system because the market appetite was so astronomically huge, right? But we understand that would be a huge investment, a complete rework of the system. We sort of put that on the shelf. And then the idea this year was let's explore the lien registry, digital asset lien registry filing. Again, thinking maybe that was a much smaller bite at the apple, but there's an enormous market opportunity out there, right? And we've seen it in the last 18 months, just with all of the, the litigation and aspects about digital assets and custody and control and trying to capture some of that market opportunity in Wyoming. So I guess I'm looking for feedback from the committee because to me, sort of the digital asset registration is a great first step, right? And it makes a lot of sense. Doesn't get us, like Mr. Crossman just said, doesn't necessarily get us to where we would be with a digital asset lien registration system. Certainly wouldn't get us where the market kind of wanted us to be 3-4 years ago with an API, right? But that's a whole different conversation. So I don't know. I feel like we kind of need to balance and focus that conversation a little bit on exactly what opportunity we're trying to capture.
Mr. Kaufman, I would certainly agree. I mean, I do, this is certainly just my opinion, but I don't think that this registry will ever reach its full potential unless there is a corresponding lien registry as well. I think because it is natural, especially with these digital assets, whether they're NFTs or some type of token or coin. By given the nature of this, they're going to want to pledge this as collateral. So I think the potential is absolutely there. And I think if we have a system that can do both of those, really good registration of the asset and the lien, I have no doubt that it'll take off in a huge way. Quite frankly, I don't know exactly what that component entails. I mean, just through these discussions, sounds like what we have does work. It's like that 96 Honda Accord with 200,000 miles. Like it will work. It'll get you from A to B. But is it is it a brand new Tesla Y or whatever the newest and fastest thing is? And Mr. Co-Chair, please.
Mr. Chairman, what I was getting at earlier was, do we need legislation or do we just need a budget amendment, basically, to get this done? If we have the capacity statutorily to achieve all of the objectives right now, except for unfortunately it's in paper, then we don't need to change statute. We simply need to put together a program, which again could be in bill form. We could run it as a bill, or it could end up being a 300 series in the budget to follow up the digital asset registration and add a lien registry. And that would be another course of action. We could get that drafted as a very short bill for next time, also as the one paragraph that describes what the objective is, and work with Mr. Crossman and Secretary of State's office on that, what that scope of work would be, and then ask for an estimated price tag as we had previously. And then obviously when we get to session, we might be able to update that a little bit better, but know what it would cost for that scope of work. I think that's a reasonable next step. And at the same time, just keep working towards that overall API outcome that we're aspiring to, which might take the same type of work down the road. Let's figure out what that costs and build it out. So perhaps to Mr. Kaufman's point, that it's a reasonable course of action for us to just put together, and it can end up being a 300 series budget amendment, but having it available for us in a one-page bill with a scope of work and an appropriation for next time is rational. What do you think, Mr. Chairman?
Mr. Co-Chair, I think it is. Certainly for myself, I don't know what I don't know, and what exactly that would entail in its totality. I don't know. But conceptually, I absolutely I think it's there because we need to at least try to feel around the edge of this thing and see what is it that we're dealing with precisely to do this. Mr. Ravel, go for it.
Yeah, thank you, Mr. Chairman. Not understanding the legislative nuances that are required here and just sort of focusing on the business case. I think it would be wise for us to not conflate the bigger, more expensive lift of the API conversion, which we've been talking about for a while now, with the idea of a digital asset lien registry, or at least streamlining that somehow. The API concept, I think, is a great one, but we are battling for basis points of market share against Delaware and hoping that because we have this added feature, we're going to get a bit more. Whereas there is no digital asset lien registry in existence. We would be creating that market. And I think that's a big opportunity.
Mr. Co-Chair.
Yeah, Mr. Chairman. Well, with that in mind, then let's perhaps do that as the focus point and ask for what that short scope of work would be, which would be something along the lines of, build an extension of the Digital Asset Registration Act to provide a digital asset lien registry. Use similar language, obviously, cryptographic signatures and all of the same compliance language we used before. Figure out what that appropriate timeline would be as we worked with the office last time to make sure that it's workable. And then an estimated budget of what that would take so that we're following up with the next step, and then see what that looks like for the next committee meeting. And I don't think that's a heavy lift, and is basically we'll finish this project and then we'll start the next project for the next opportunity. I see Secretary of State's interested.
Mr. Secretary.
Thank you, Mr. Chairman. And yes, we're happy to prepare that for the November meeting. I want to underscore Mr. Revel's comment that I agree with, that let's not conflate the two things. They are very separate. So in my view, but happy to prepare that for you for that November meeting. Thank you.
Mr. Ravel.
I just wanted to point out that the secretary is the first one to pronounce my name correctly today, Revel. So thank you, Mr. Secretary. For the record.
Reveal.
Revel.
Revel.
Reveal.
Revel.
Revel.
Revel. What's that?
I do think.
What's the? Mr. Chairman, what's the purpose of that E at the end then? What's it doing there?
There is
Revel.
no E.
There's no E. Man. Yeah, look at that. All right.
Yeah.
Yeah. Well, on behalf of the
Issue a
select
correction.
committee
Yeah.
and
We'd like to issue a
all of the
correction.
stakeholders, we'd like to issue a correction and note that it is.
We deeply regret
Mr.
any
Joel
errors.
Reville. Heretofore.
Mr. Chairman, I've been trying to figure out for an hour how they're getting to that pronunciation off the way it's spelled on his name tag.
Maybe just for kind of the committee's edification, what were the holdups? Or what was the conclusion we came to last time? Because if I recall correctly, we let it fizzle out. Why was that exactly? Mr. Revel?
Yeah, Mr. Chairman, I think
Co-Chair.
we're in good shape, honestly, to move forward with where we're at. I think the only reason was that we needed to get the digital asset registration system up, understand where we were at on that before we could really proceed with the lien registry. And so it was more of a timeline concern. I think based on what we're understanding, it's going to be working, it's going to be operational in December, and that taking the next steps is reasonable at this point. I would ask as part of this endeavor to really explore, are there statutory barriers that we're just not coming up with? Because I think it's important for us to understand that. Ask David to take a look at that as well, see if there's any statutory barrier. I just don't think there is one. I think we're probably fine to automate facilitate a better process is all we have to do, I think, I hope.
Mr. Secretary?
Well, Mr. Chairman, I don't want to put the attorneys on the spot from our office yet on, doing this on face value, but I can tell you, I'm getting whispers that, there are some things maybe we need to look at, because the question of whether that registry confers ownership, that in the language, that's, I think, a question there that might require some revision. But why don't you let us, are you okay if we maybe brainstorm it a little and get more of a formal position? Because I do think there might be some revisions, or even thinking about it conceptually.
Mr. Secretary, we're fine with that. So we'd rather, we're collaboratively take our time a little bit to get this right than rush through it.
Yeah.
Senator Nethercott?
Mr. Chairman, I think, Joel,
Reveal.
where's the,
Rebel. Revel.
I'm just.
Mr. Revel.
Mr. Revel.
That's more for us, not for the audience.
Thank you. Mr. Revel Kaufman.
So I think there's kind of a failure to articulate maybe more thoroughly what the concept is. So the question is whether or not the UCC filing system creates a security interest in a digital asset. And the answer is it can, but do we want to make something different to put Wyoming in a different position as other than just a standard UCC filing system? Is that what you're thinking?
Mr. Rebel.
Thank you, Mr. Chairman. In all honesty, Senator Nethercott, I don't know the legislative or legal work that needs to be done. I am stating a business case that is, I think there's a significant opportunity here to create a registry for digital asset liens.
Mhm.
And the more that can be streamlined for participants and accessed by courts, et cetera, the better. I mean, that's your area of expertise. So that's the limit of my knowledge on how it's best done.
Senator Nethercott, follow up.
Yeah, so the question for the committee, and I think doesn't make sense to have a lien filing system for digital assets outside of the current UCC filing system. Mr. Kaufman.
Actually, real quick, Mr. Kaufman, I think Mr. Pope wanted
Oh,
to
I'm sorry.
jump in.
Just quickly, Mr. Chairman, for me, the question is, if we get 500,000 digital assets that are registered within the state of Wyoming, and in 1 year we get 125,000 pieces of paper that are lien filings, how do we deal with that? And the logical answer is that if it is an electronic system, then it is far more cost effective for the Secretary of State's office and for the state in general to process those liens.
Mr. Kaufman, go for it.
And Mr. Chairman, I could just jump in. And so just to be clear, yes, I'm 100% in agreement that we should hopefully and work towards, I think what we're all talking about here, the holy grail being sort of a blockchain based on-chain, right, digital asset lien registration system. That's right. That's the best case solution. But I think we've all decided that's right. That's a step out here. So that's why I was asking the question, are we aiming for that like we were with the API? Because I'm in agreement with Joel. The business case is there. Now you can file UCC lien statements through a portal or fax submission, right? Whatever. I mean, like Mr. Crossman said, essentially it's a fax filing. Maybe you can access that in some digital format if you're a regular user, right? So are we just talking about some electronic system where you can get on and register? Or are we talking about something on chain? That's where I'm struggling to find the distinction, because frankly, I'm on board with either of those routes, but I think we need to be really clear and get feedback from the Secretary of State's office as to what we're doing. Because I mean, I can right now by contract with you, Senator Nethercott, say I'm taking a lien interest in your Bitcoin and walk down to Colin and file my UCC statement, right? And I probably have some enforceable lien rights against your digital wallet. So that's not, and I think that's what testimony we've heard today, that's not prohibited now, right? That's the same in every state. We're talking about a new type of filing system that would make it more accessible. And I think that's where I was trying to help Mr. Revel make that connection to what was being testified to earlier, is in my mind, again, the business case out there is a lawyer in Delaware or Chicago or New York can make a portal or fax submission or, a UCC filing now. We're trying to make that hyper accessible and instantaneous, right? And hopefully be verifiable on chain, which is a little bit of a different technological capability than what the current UCC filing system has.
I think also, Mr. Co-Chairman, Mr. Calvin, I think it's a really good point. I do think we have been talking about this in the philosophical hypothetical, right? They were policymakers here. I know we've got some attorneys in business practice, but I'd be curious to see or hear from folks, input from subject matter experts who would be our potential customers in this and saying, okay, for us to use your system at the volume to make it worth it, these are the things we need to see as A, B, and C. And that's the thing I think at some point we might be needing that type of input right now in this discussion. Mr. Co-Chair.
Mr. Chairman. I think that the vision is accomplished by an extension of what the Digital Asset Registration Act is already realizing through what Mr. Crossman said a few minutes ago. If you've got a required on-chain registration, you've got a verifiable identity, then you have an easily accessible reference asset that you could hang a lien off of through an additional filing on chain and certified, assigned by the state. So it seems that it is a reasonable extension of their existing workflow. I guess I'd look to Mr. Crossman to see if he sees it differently, but I feel like everything that is desired and has been expressed is a reasonable next feature built on the same technology approach as what is being used right now. So I'd look to Mr. Crossman, but we can talk more.
Mr. Crossman.
Mr. Chairman, to be, I guess, clear a little bit that there's effectively three different systems being talked about here. We have the current system, which is a hybrid online paper initial filing. Some initial filings can be done online, and it's a PDF. Paper submissions are done, and they come in and they're scanned in and they're reviewed. The next tier system that we are considering is a 100% online system that has paper as it doesn't preclude the filing on paper, so that anyone who wants to file on paper, who can do so, and we'll take it in, but it is immediately converted to a digital format, and then everything is processed digitally. That system could be adapted to use with be connected to an API. Potentially, because now you have a system where everything can be done in a computational manner. So an API can be built out or linked, or and I believe in some cases the API for this already would exist, because that's functionally how you build software. You use an API. So you have a front end, and it connects to an API, which communicates to the back end. Beyond that, I'll have to have a lot more discussion as to see where and what people are trying to get at. Because an API-based system, what we have a business registry is a centrally authoritative registration. And I will have to see I have to really understand how a centrally organized, centrally authoritative, central trust system comports with a decentralized, trustless blockchain. So I don't see how those two things necessarily are marriageable in that sense. Once you have an API, however, there would be nothing precluding people from taking their registrations and putting it on this blockchain or that blockchain. But for this office to have filings directly on a blockchain, I will have to do a lot more research and understanding to see how that might function, given the constraints that a widely distributed, functionally trustless system would work. And if you have a trusted blockchain, well, now you're taking on all of the overhead and burden of a blockchain, the computational, the storage, all of that burden, when SQL can do the job. So I think that is the step 2, which is a computational filing system using APIs. That system is, I believe, not only eminently doable, but I think where we're headed and where we should be headed. Step 3 is something that we really need to really think about and figure out both the business case, the legal case, the practical case as to how those would work. Because connecting the two things internally may not be the best way to go. Maybe we let the private sector handle that. Maybe we let third parties handle that. I mean, I think at this point, I'm rambling, but there you go.
Mr. Crossman, that's what we do here.
Yeah. A good point. I think we're good.
Mr. Netcott, we need to talk more. Mr. Rillo? I think
I'm going to start, Mr. Chairman, and Mr. Kaufman's going to be my lifeline here potentially. I think there is Mr. Kaufman referred to a holy grail as being on chain earlier. I do believe that is a holy grail, but is a bigger lift and may inadvertently alienate us or put us onto a chain that doesn't end up being compatible for whatever reason that we can't foresee down the road. Whereas I think a electronically accessible registry that is not yet on chain is maybe the first place to start.
Mr. Chairman,
Mr. Co-Chair.
I think these aren't questions we should answer right now, is what it comes down to. A couple of them. I mean, like as far as the details of the specification and how it should play out, probably needs more time and thought than what we'll put into it here. The objective, though, like the goal, I think we understand that reasonably well, that we want to achieve a digital asset lien registry. So we keep it specific to that, start moving in that direction, ask the Secretary of State's office to do a little more work on figuring out what that timeline might look like, what the budget might look like. And then in parallel to that, we start figuring out some of the answers to how we implement that. Because at the end of the day, yeah, we certainly do want, if you have a digital asset that is on a specific blockchain where its ownership is recognized, we've attested to it. And as indicated, part of that workflow is going to be that attestation is put onto that blockchain. That's the appropriate place for any lien to be noted, would be an attestation and a cryptographic signature by that party, by the state of Wyoming, and by perhaps the third party, the counterparty. All three signatures should be an attestation on that blockchain at the same location linked back to the asset. That one more time, attestation. My attorney over here is giving me advice. So that doesn't mean picking a blockchain. That gets to the same workflow as is done right now, which is, well, we're handed some digital asset that's on a blockchain. We figure out how to deal with it, is pretty much the summary of what they're doing right now. And I think that's going to work too for this. It just might be from time to time they have to upgrade how they interact with it, a new blockchain technology, but we don't have to be technology specific to achieve that. But that's the utility, in my view, is not having to inquire with the state of Wyoming, is there a lien existing? if you've got the digital asset address on chain, the liens should be self-evident on chain through some type of attestation. At the same time, Senator Nethercott. So I think we're okay, is what I think. I feel like we're in a good place to move to the next meeting. We don't know all the answers yet, but we're going to find those, a lot of them out before the next meeting, hopefully, and then figure out how to proceed, Mr. Chairman.
Mr. Co-Chair, I would concur.
All right.
Mr. Crossman, Mr. Secretary, I mean, is that moving forward, that kind of the idea of a digital registry for digital liens, is that something you guys are okay with at least pursuing? Not again, the on-chain stuff, but at least more simplified, easier target to hit.
Mr.
Secretary?
Chairman, we're going to get back to you on those questions that you brought forward. Both the co-chairman brought forward. So happy to move forward in that way.
Excellent. Thank you.
Thank you.
We're a tad behind schedule, but I think that's okay. We
still have the expedited files.
yeah, that's right.
So not so fast, expedited filing.
Yeah, not so fast. We're not done with the secretary's office. Yes, or yet. Mr. Hopkinson, is it okay if you come up and
You want to do it from there? You can-
or yeah, you can.
In the
Yeah,
interest of time.
let's just keep you guys here because we're up here.
make it
We can
short, Bill.
let David do it from there.
Mr. Chairman, before we jump into that, can I just clarify? At this time, there's not a formal bill draft request with respect to the digital asset registry, is my understanding.
There is not.
Okay, just wanted to make sure I wasn't,
Yeah.
Mr. Chairman,
was not.
Mr. Chairman, yes, there is. I disagree. So the yes is that we need to work with the Secretary of State's office to figure out what that ask would be. It's just going to be a one pager of here is a work, an order of work, here is a cost, and that's what it would look like if we come to a conclusion there. And I say that we want that so that we actually have it to look at the next committee meeting if one exists. If we fail, that's okay. But I think we should have authority to be drafting that so we can consider it in November.
You got that, David?
No.
Attestation. So
I think we just want a simple scope of work, like a one
Yeah,
page that we'll do in
exactly.
consultation with the
So-
secretary's office.
one section that says Secretary of State's office shall create a lien registry for the digital assets, Wyoming Registered Digital Asset as a continuing work product of that project. Here are a couple of parameters for it. Those parameters are up in the air, and that's what we're asking the Secretary of State's office to figure out what that might look like, what needs to go into that, and we can work on that collectively between now and November, and then what the price tag and timeline would look like. So some due by dates. Similar to what we did with the Digital Asset Registration Act, but that was relatively complicated, and this is going to be add on a digital lien registry.
Just a good little
It's a
bit.
new feature.
Mr. Hopkinson,
So
are you any,
is the ask then for a bill draft that directs the Secretary of State's office to do those things? Or are we just kind of waiting for them to sort that out and then you want a bill draft? That's what I'm not quite following, Mr. Chairman.
Mr. Chairman, we've only got one more meeting, so whatever happens needs to happen at the next. And what I'm hoping for is the capacity to fund the project through a bill draft so that it doesn't have to necessarily be a budget amendment. It's the kind of thing that would look like a 300 series budget amendment, but as a bill draft.
So, Mr. Chairman, to clarify then, you're looking more for something in line along with what we've done in the past with respect to asking the Secretary of State to develop the filing system with API as opposed to a draft that would actually go through the statutes and incorporate, what the Digital Asset Registry did, setting up the system in the statutes, requiring rulemaking, that sort of thing. Because I don't think we can do a one-page bill draft that would actually accomplish the creation of the Digital Asset Registry.
Well, the digital
For
asset
lien registry.
Right. The build out was what we were talking about, because it doesn't sound like we have to have any changes since they already implement UCC filings. They'll have the digital asset registry. The lien registry is more of a feature build out. And what I was anticipating for us to talk about would be, again, what would look like a section 300 of the budget of a couple of paragraphs of funding for the Secretary of State's office to create a digital asset lien registry to facilitate the registration of liens cryptographically that relate to assets registered pursuant to the Digital Asset Registration Act. So effectively a budget note as opposed to legislation changing statute. Wouldn't need to change statute at all. Non-codified is sufficient. Unless we think we need to change statute. I'm envisioning non-codified law that provides budget. If we find that we need to change statute, then that certainly changes the scope. And this gets back to the question of, do we need to change statute? And I see Representative Yin has his hand up. He might have some.
Representative Yin.
Mr. Chairman, thank you. So maybe something like House Bill 142 from 2021, which was our previous API, create an API bill that had a price tag appropriation on top of it, plus something language that said build an API, and it was all non-codified.
Mr. Hopkinson, has any of this guidance been helpful?
Mr. Chairman, that is helpful as far as what the specific ask is, and I'm absolutely happy to do that. I am less optimistic that we won't need to make any statutory changes, but that's something we can examine down the road.
All right. By God, we got there, folks.
We're there.
We are there. On to our next agenda item, Bill Draft 24 LSO 0105, Secretary of State expedited filings. David, do you want to walk us through this one?
Certainly, Mr. Chairman, thank you. David Hopkinson with the Legislative Service Office, walking through 24 LSO 105, working draft 0.6. What this bill draft does is it goes into the powers of the Secretary of State's statutes and creates a new paragraph 8, that provides that the Secretary of State shall collect the following fees in advance for, and then paragraph 8, new language on page 2, line 4, expediting the filing of any document, a maximum of $2,000. Then provides that notwithstanding any other law to the contrary, the Secretary of State may charge a fee as specified in this paragraph to expedite the filing of any document filed with the Secretary of State's office pursuant to any applicable filing requirements upon the request of the filer. The fee and process for requesting an expedited fee filing shall be established by rule of the Secretary of State, taking into account the cost of the filing fee and the cost of expediting the filing. And I want to pause there. So what we've got essentially is, up to this point, a $2,000 cap on expediting the filing, a provision that the Secretary of State's going to provide or promulgate rules for how that process works. And it would be at the request of the filer that the filing be expedited. The last sentence here kind of carries a lot of water. It's the expedition of a filing shall not grant any benefit over a non-expedited filing for purposes of the timing of the filing. Now, the purpose of that language is to try and kind of capture a situation where someone, files, say for registering a corporation, and then someone else the next day realizes what they've done, decides they really like their corporate name. So they file and expedite their filing. And now all of a sudden there's this conflict and they would have potentially stolen, in a sense, that corporate name. So the intention of this is to say, no, even though you filed, your filing might have been completed first, you don't gain any benefit for the purposes of that timing. Of course, the costs and everything like that depends on, is up to the policy question, up to the committee. The only other thing I would note then is if the committee wants any kind of promulgation deadline for the rules for the Secretary of State's office, but certainly that's up for discussion. And with that, I'd stand for any questions.
Any questions for Mr. Hopkinson? Seeing none, I do think that's an important delineation, the This is just expedition of the processing, not of the time it's actually submitted. Seeing no questions for Mr. Hopkins from the committee. Mr. Secretary, Mr. Crossman.
Thank you, Mr. Chairman. Again, for the record, my name is Chuck Gray. Have to my right, Colin Crossman, our business director, and then to my left, Joe Rubino, our general counsel and our policy director. Talking about 24 LSO 105, first I wanted to note that the Wyoming Secretary of State's office can implement this legislation as written by allowing the Secretary of State's office rulemaking authority to set a fee and provide a process for requesting and approving expedited filings. The bill ensures necessary sideboards to expedite service where appropriate, while ensuring that many of the office's regular statutory filing deadlines of 15 days remain operable. With this balance, both the concept of the bill and maintaining service to existing customers who do not pay for expedited filing are achieved. And again, I want to emphasize this, that we are concerned with this 30% growth we've had. We want to keep our 15-day statutory deadline, and obviously we're going to meet it, and we want to meet it. And so we need to set the fee high enough to where it'll be enough that it's not going to bring back the normal filings beyond the 15 days. And we believe $2,000 is, we'd ask to not go any lower than that on the cap. And talked a little bit with Mr. Kaufman on that. And I'm going to turn this over to our business director after I'm done on some other states and why we think that sort of sets us up to where we're going to be okay in continuing to meet our 15-day deadline, which we have a strong position that we do not want to be revised backward to provide more time for expedited filings. We believe we can make it all happen within the 15-day deadline, including the expedited filing, if the fee is at the appropriate level, and believe that at least 2,000 is where to be. I do also want to quickly highlight current language in the bill that, quote, the Secretary of State may charge a fee as specified in this paragraph to expedite the filing of any document filed with the Secretary of State's offices pursuant to any applicable filing requirements upon the request of the filer, unquote. And I overheard, Chairman Nethercott talking a little about, I think she may have been referring to this. As members of the committee know, our office does handle a wide array of non-business filings in our other divisions. While many filings make practical sense to allow expedited service, such as those in our business division, others, such as those in our elections and compliance divisions, do not. As an example, these filings would include lobbyist reports, oaths of office, ethics reports, etc. So long as rulemaking authority exists, ensuring our office can determine the process for expediting filings, as well as which filings may be expedited, as I believe the bill currently allows, we will not run up against any unintended consequences from the legislation. At the same time, I'm open to amendments to further put some sideboards on that question. We did not bring language here, but as the bill continues to work through, happy to work with members in the committee on language we could do. But we believe the current language, with that discretionary authority, we just be able to provide and rule which filings are eligible and which ones are not. The other question before I turn it over, before I conclude and open it up for questions, and also would ask the chairman with his indulgence to allow Mr. Crossman at some point to comment. This last sentence about the expedition of a filing shall not grant any benefit over a non-expedited filing for purposes of the timing of filing, unquote. We've had considerable discussions within our office about this. Certainly agree with the concept 100% on it. Now, when you have a paper filing in a bin that gets processed day 11 and somebody's expedited a filing, that name check will have not happened yet. And so in theory, if this happens, the way our system is already set up, in theory, someone could already do this by filing online. But it hasn't really happened to our knowledge. But the way we said we'd comply with this is we just back out the filing once the day 11 name check would come back with it conflicting with the expedited filing. So certainly agree with the concept. We don't want this to be used to be able to steal corporate names in terms of implementing in our current practice. It might be complex if it happens, but could happen in our current system anyway, if someone used our current system in a certain way. So we'll make it work. Thank you.
Thank you, Mr. Secretary.
Mr.
Mr.
Chairman.
Secretary, real quick, did you say that this would only apply to business filings despite in the language it says any document filed? Did I catch that correctly?
Mr. Chairman, the statute stands, so it would apply to any filing, but we believe because we have rulemaking authority, we could through rule designate which filings within our office would be expedited and which would not. There are many, again, that do not make sense to expedite. Just wouldn't work. Some just wouldn't work. And so we believe we could implement it via rule. At the same time, if you want to narrow the scope and apply it to just certain business filings, I mean, we have many, many filings just within our business division, and then you talk about the other divisions. So there's two approaches to address that issue.
Mr. Secretary, thank you for that clarification. I think Senator Nethercott.
Thank you, Mr. Chairman. I think the secretary overheard my comment to my colleagues. My concern was related to the issue that's evidently been thoroughly discussed concerning line 14, which is just that language for the expedition of a filing shall not grant any benefit over a non-expedited filing for purposes of the time of filing. I do think more thought needs to go into that, and we can tighten that language up a little bit more in order to effectuate its purpose. I can see that language is so specific that it cannot be softened or resolved, I don't think, with any kind of rulemaking, and want to make sure we don't create any kind of litigation, because there is a benefit created by expediting a document, which is why they're expediting the document. But we don't want to create this unfair result from somebody expediting, and it's really just supposed to be for their personal convenience, for whatever personal reason they have. That likely will be the intention, but it will have an impact potentially with someone else, as what currently occurs without the expedited process. So I just think we need a little bit more thought. In relation to the issue brought up above, I think the solution of hitting any document, any business division document, is a good solution, but that wasn't my concern. Thank you, Mr. Chairman.
Thank you, Senator. I certainly do agree. Maybe just tacking on some language talking about any filings within the business division, because that's obviously our sticking with the intent. Mr. Secretary, I'd have a question. Caps you at $2,000. What number do you guys think is the right one, and why, or how did you arrive at that number? Go ahead, Mr. Secretary.
Well, Mr. Chairman, some of this is a gut that it's kind of a balance, right? You don't want too many where we're going to go above the 15 days with our current staff. And I've committed in this upcoming biennium, we're not going to ask for any more positions. And there was an article about that the other day, despite our 30% increase. And then we also studied other states. And I think those two things together, we came to the cap being at 2K. We think we're going to be okay on it. But I want to turn it over to Mr. Crossman, talk a little bit about our research from other states.
Mr. Crossman, please. Go ahead.
Yeah, Mr. Chairman. So our primary competitor states, Delaware and Nevada, have expedited filings, and their filings, they for certain things they can charge upwards of $1,000 or more for that process. We wanted to make sure that we had headroom so that we can, without having to go back to the legislature in the future, that we would be able to create a gradation or a set of expediting criteria that sort of match what Delaware and Nevada do. Other states, many states have expedited filing. Some are very inexpensive. Texas is only $25, but Nevada and Delaware do go up into the thousands. So that's why we pick the 2,000 figure, and we intend to create in rule the precise amounts. And we wanted also the ability to adjust more quickly if we're seeing too many or if we get pushback that it's too expensive. To speak to the concern about the last sentence, one thing to understand about Wyoming, as opposed to many other states, is how we treat a filed document. In most states, a filed document is effective at the moment of filing. In Wyoming, it's effective on the moment of receipt. That's elsewhere in statute. So technically, an expedited filing is an expedited processing, not an expedited filing. Because so if you submit a paper filing to our office, it is technically live the moment we stamp it in, even though we haven't processed it. We get to processing it within the 15 days. So in the current situation, if somebody were to file an initial filing by paper, and then somebody the next day were to file for the same name online, the online one would be accepted because the paper one hasn't been processed, but technically the paper one would still have precedence. So that last sentence, I think, just clarifies the reality of how our filing system works in other elements of the statute. So whether or not it should be adjusted to make that more clear, I leave to you all, but I think that's what it's attempting to get at. The reason why this expedited filing is, at least the reason why I've been told this is desired, is not so much because of the effective date. So if somebody were to file, and also this is not so much about initial filings. Initial filings are online and they're instantaneous. So you can get it, you can get your LLC up and running today if you want. No need to pay $2,000. This is for certain documents that people need to file and need to have a very specific date due to regulatory situations in the federal government, other states, or other jurisdictions, and they absolutely need it to be, for whatever reason, on that date live on our website, because other states and the federal government don't necessarily understand that in Wyoming we treat it as effective the moment we receive it, and it has that little blue stamp on it, not when it has the accepted for filing stamp on it. So that is what this is for. And we also, as the secretary alluded to, we don't want to have this fee so low that a whole bunch of people just start paying. If it's $25, our filing system is so we have so many filings that, oh, it's only $25, and we get 200 expedited filings that day that now cause us to push back the normal filings. Well, both of them have that same 15-day statutory deadline that we're up against. So we don't want to have it so that we want this to be the kind of thing where only people who really need it do it, basically.
Mr. Chairman,
Senator Nethercott, please.
just a question for Mr. Crossman on page 2, line 16. Since the operative time is the time of receipt, should that language be changed to the time of receipt instead of to the timing of filing?
Yeah, thank you, Mr. Chairman. I would agree that might be a worthwhile modification.
I'm sorry, I can't go for it.
We'll wait for the bills move.
Well, members, is there any other questions for Secretary? Which co-chair?
Thank you. A couple of questions. The first is with regard to the language change that would be plausible to ensure that we're just talking about business documents. And my question is that an appropriate term of art if we said expediting the filing of any business document and then amended accordingly, business document instead of any document? Is that an appropriate term of art that clarifies what we're talking about, or would that also potentially apply to elections? I don't know.
Mr. Rubino.
Thank you, Mr. Chairman. I think there's a couple of ways that you could go about it. I think, and I heard a little bit maybe from the committee, I think the best wording would be a document filed with the business division of the Wyoming Secretary of State's office, or with the Secretary of State, to conform with the So a document filed with with the business division of the Secretary of State's office.
Mr. Chairman,
Mr. Co-Chair,
is the business division of the Secretary of State's office something that is in statute? Is that a statutorily enshrined entity, or is that simply an org chart? Because I mean, I know that we've had that. I know that's been there certainly longer than I've been in the legislature, but I don't know that it has standing. So I don't know that that works.
Mr. Rubino.
Mr. Chairman, you could also, to your point, I think you're correct. You could also enumerate titles that it's filed under. Title 17, Title 34, that would eliminate all filings under Title 22. That would, you know, I think that might be, to your point, to get a little bit to where you're.
My attorney says so, yes.
I think that brings a high level of specificity that we're going for here. We can certainly, once we take the bill for formal consideration, we can bring that amendment.
One more.
Is there anybody committee or Mr. Co-Chair, please?
The other one is $2,000 always enough. I realize that that's, and what I'm imagining, I don't know whether we'll get to this stage, but you know, you get a call at 10:30 on a Sunday evening or something, and they bloody well need you to have a filing ready that registers for that day by midnight. So ridiculous circumstances. I don't know if we just don't want to pick up the phone for that, or if we just want a very, very high number that's daunting. And I guess I'd just throw that out there as we're drafting the legislation. How far do we want to go for the maximum filing cost? And is $2,000 enough?
Mr. Secretary?
Yeah, and Mr. Chairman, I think I could have been a little clearer on that. Our position is that we don't want the maximum to go any lower than 2,000. So if the legislature wants to raise that maximum a little bit, we're going to try to get it right over time. But we think 2,000 is the lowest we'd like to go on that potential maximum. Again, this is, you know, just for the record, and I know everyone here knows this, it's like the Chancery Court. This is just what the maximum is. It's setting a cap,
The
potential
minimum,
cap.
the minimum maximum. Members of the committee, any further discussion or questions for the secretary? Seeing none, thank you very much. We're going to go ahead and turn over to public comment. Is there anybody in the room who wants to, please go ahead? Yeah, Ms. Barker, we know who you are, but just for the formalities, just introduce yourself and who you're with, please.
Yeah, hi, I'm Jade Barker. I'm with Silicon Prairie. We have a empire of regulated financial entities, but we are primarily technologists. We have an investment crowdfunding portal. We have a transfer agent, and we have an investment bank, which is a FINRA broker dealer. So I definitely wanted to make a couple comments, but we'll try and keep it short. I just have 2 points that we'll go through.
Please go ahead.
Okay. This is my business partner, David Duccini. He's deeply technical. So again, if you guys have any questions about how to structure a software project, we would donate some time to just whiteboard some stuff out for you. For example, just doing an MVP and making your software choices for the API, all that sort of stuff, iterative, break it up into phases. It's fine to have the MVP being like, just get it electronic at first, and then you step up as you need it. Totally normal sauce for software people. All right, second piece, because I've got a transfer agent and I'm the president of that, and we're literally in the process of writing up software for how to handle private securities. If there's something where a security or a coin is being registered at the state level, that triggers a bunch of stuff for my transfer agent hat to think about. Unclaimed property. And I just really want to encourage you guys to be thoughtful about unclaimed property rules are really specific for financial securities. So for the transfer agent side of things and their trade group, they really hate Delaware for escheatment, which is basically if everybody registers their company in Delaware, so all the stock goes back to Delaware. And after somebody who's a shareholder dies, if the transfer agent does not find like next of kin to handle or the securities to that right person, the state eats it. It's like literally a huge portion of Delaware's. Yeah, it's a third of a certain type of their revenue in Delaware comes from eating the debt essentially. So if you want to have an advantage in the right, if you want to have an advantage compared to Delaware, that might be one of those things from the transfer agent side of things. So just think about those lost shareholder, because there's real tight constraints around having to find somebody. So if you're talking about registration, making sure that there's even just some wording that says, okay, maybe there's just a sentence somewhere that has to say, if you can't find this person, the issuer of that security or that coin, maybe they donate it to a foundation or something that would cut off that whole chain of events.
Committee, any questions for Sparker? Seeing none, I'm bummed that your electronic name tag.
We tried to turn them off so they're not distracting while we're in the room, but if you want to find us, we'll be here all week. We love you guys. This is the best part of our year. So it's just stunningly good to watch government actually work.
Well, thank you. We take pride in that. Seeing no further questions at this time, thank you very much for your testimony. It's been over the years. We've greatly appreciate it. It's been very valuable.
I have a couple of comments, please.
Please, of course.
Thank you, Mr. Chairman. So I'm David Uccini, founder of Silicon Prairie. As Jade said, we're a collection of financial technology companies. We started in 2016 as a state-based crowdfunding portal, became a transfer agent in 2018 and a registered broker dealer in 2020. And since the last time I saw you, I'm pleased to report that after an arduous process of 23 months with the SEC and FINRA, we have been approved to operate an ATS, an alternative trading system. So secondary sales is near and dear to our heart. We now say that any investment without an exit is just a donation. So I think what's interesting potentially about, and I've not read your digital asset registry, but I would think that potentially it could legitimize essentially a friction-free secondary sales, which the lien stuff is certainly interesting, but right now there's a lot of buzz around limited partnership interest and the ability to have secondary sales. And so again, most state blue sky laws around securities have all these weird restrictions around you can't have more than 10 isolated non-issuer transactions, blah, 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 blah. And so it would seem like you may have the unintended consequences may be that you've just created a path to register a security that's recognized by your securities administrator, in which case then that might just facilitate friction-free secondary sales without all having to jump through the hoops of, this basically what's called an exempt transaction. So that might be actually a lot more interesting in the meantime, because you might already have that baked in and built in. And secondary sales, like I said, it's super hot. There's only 40 ATSs in the US. The last 30 years, at least 30 of them have only been like dark pools for insurance companies. And so there's only a handful of small companies dealing in digital assets. So good job, even if you didn't intend it.
I remembered one more thing, guys.
Please, Ms. Parker.
All right. So there was some conversation about whether or not you need to have one chain or two chains for the liens, rights, whatever. This is again something that you could solve with a multi-signature wallet, where if you've got 2 of 3 keys are mandatory in order to have that cryptographic signature and the transaction go forward. So you could have one state registry, and it's chain agnostic as long as that particular technology supports multi-key signatures. Then the state has one, the issuer has one, and then if there's a lien, another key is added, and you can basically put a boot on the Ferrari, and those securities can't be driven off.
Thank you very much, Ms. Parker. That's certainly, and Mr. Duccini, I'd like to think we intend everything.
Apologies, Mr. Chairman.
Committee, any questions for Mr. Parker or Ms. Parker, Mr. Duccini? Seeing none, again, we appreciate all of your input you've given over the years. It's been very valuable.
Yeah. Huge fans.
Is there any additional public comment in the room? Please. Ms. Spielman.
Hi,
Spielman,
Lisa.
correct?
Yes, thank you, Mr. Chairman. Lisa Jody Spillman, partner with Sterlington Law. I just have a question. I represent a number of Wyoming small businesses. And with respect to that expedited processing bill, do we have an idea of the extent to which, if at all, the processing time of individuals who don't want to pay the extra amount of money is going to slow down?
Yeah, Ms. Spielman. So right now they're statutorily obligated to fulfill those commitments within 15 days.
Right, I understand that. I'm just curious if there's a amount of time that they do it now as average and whether or not that time is going to increase.
Ms. Spielman, that might be a question better directed towards the Secretary's office. Ms. Crossman, if you'd like to come up, please.
Thank you, Mr. Chairman.
Mr. Chairman, our goal would be to set the fee at a rate where this would not impact normal Wyoming filings from normal citizens. This is, we see this as a tool for much larger entities who need something done very specifically on a date to do it in a formal way. I don't, I mean, as I said earlier, if we set it at $25, that would be so low that we would get everybody paying $25. It would effectively be an extra tax on filing business filings. So I anticipate that we will take the route that Delaware and Nevada have taken and set those fees at a high enough point that only people who really, really, really need it want to pay that fee. And that in normal, everyday citizens don't need to think about it, don't need to pay the fee, don't want to pay the fee, and don't pay the fee.
Ms. Spielman, I hope that helps.
Thank you, Mr. Chair.
Any further public comment in the room? Mr. Stokes, excuse me.
Thanks for having me. Try and make this quick. Going from a closed system to open system seems like quite the engineering feat. I mean, the solution exists. It could be a bit academic, but I think we could go from like nested systems of closed to open, like using potentially IBM Hyperledger or Dr. Gideon Greenspan's multi-chain, which is based off Bitcoin Core. So essentially that's a permission chain that you can delegate certain specific permissions to the addresses. And then, you know, you could essentially use the permission chain as a legal container for the open chain assets. So it's a realistic solution that could be done today. So
Thank you, Mr. Stokes. Any questions? Seeing none, thank you for your testimony. Clarissa, is anybody in the Zoom world? Oh, fantastic. Brendan, please.
Can everybody hear and see me?
We can hear you. Go for it.
Oh, great. Yes. Thank you, co-chairs Rothman and Western and committee. Brendan Marr. I've been on the working groups for the Digital Registry Act and also the Digital Identity Act. And there's a few comments I have regarding thinking about going forward. And first, I want to say right off the bat, a side comment regarding Mr. Grossman. He's fantastic. He really does have a handle on all of this. I'm sure you're aware. So he's a keeper. Please take note. You know, we wouldn't be here without you know, his tremendous astuteness to the details here. And having been pushing this for many, many years, cryptographic registrations, you know, this is just a great joy. And it is also in part, you know, why we're in the pickle we're in. But I do want to offer, and the pickle, this is a good thing. I do want to offer some ways of thinking about this. And it's very important, I think, to separate out the cryptographic signing part from the asset part. I'd like to address Co-Chair Rothfuss' comment regarding you know, legal and statutory authority. Co-Chairs Rothman, Western's comment about the glue, Mr. Ravel's comment about you know, the lien registry and so on and so forth. It is really important to think about and know that you don't have to build all these systems at once, and they can be built out in a way in which you're dealing with the cryptographic signing part entirely separate from the asset part. And this is really, really important, because if you have a entity that you're registering registering. Certainly from the Digital Identity Act, I can take on my side of the fence as a founder, I could, take all my documents, I can cryptographically sign them myself. I could take a photograph of them as a PDF, and I can cryptographically sign that photograph, and I have a digital signature. And under the Digital Identity Act and UCC, UIDA, that is all legal. The question is dealing with the registry part of the assets. And when we talk about entities, it is also the case that you can register for them. You can formalize that with cryptographic signatures, and that's entirely different than the asset part, because as a founder, I put money into the entity. I can cryptographically sign, but the funding of that entity may or may not be with cryptocurrency. It might be with fiat currency. So, clearly we have this stage rollout, and thinking about these things is my urging for the committee, that they go along this pathway in terms of solving these problems, because they can't all be solved at once. I hope that is constructive. I'll take questions.
Mr. Meyer. Thank you, Mr. Meyer. Committee, any questions for Mr. Meyer? Seeing none, I did have one that you mentioned about the commercially registered agents component in this digital asset registry.
Yes, please.
Just where does that all fit in into this discussion from your perspective?
Oh, thank you very much, Co-Chair Western. This is extraordinarily important. I'll be quick about it. It's very simple to understand. The reason why a commercial registered agent is critical is that if you're going to cryptographically sign something, the stuff that you get back from the signing process, and Mr. Grossman could comment further on this stuff, is binary numbers. They're not human representable, right? It's like, when everybody uses, the computer, and the computer, a lot of times it spits back junk, all these like funny characters on the screen. Well, that junk is not always junk. Sometimes it's just is meaningful information, but it's encoded in binary, right? So there's this whole process, and by the way, listen, this happens all the time. Every email you send, there's cryptographic signing going back and forth between the servers, right? This is not a mystery. Okay, the difference here is that all of these things that are cryptographically signed with email and web pages going back and forth, the only thing that the Web3 stuff adds from that standpoint is a different format, right? Instead of having a digital certificate, you have the specification of the chain that provides the information of how those things should be, how that cryptographic signing should be expressed. Okay, the reason, to answer your question, that the commercial registered agent is critical is because we need to ensure that the process is done in a way in which, when it is cryptographically signed, right, the cryptographic output of that cryptographic signature is in a format, and there are many of them, in which it's not only human readable, but maybe it's human readable and one in which you can send it through the email, right? Or human readable, but not really long, like hexadecimal, but a shortened version, or one that has error correcting codes in it, all this kind of stuff. So not to be, too long-winded on that, you just want to make sure that you don't write a statute that says you can cryptographically sign something, and then you get somebody who's a registered agent with all good intentions, who is at their ranch and says, okay, well, you cryptographically signed this, or I cryptographically signed it, and it's in a file format, but then when you go to copy and paste those characters, they get lost because you can't see them, because they're not viewable, because certain characters are in binary are not renderable to the screen. I hope that helps.
Thank you, Mr. Meyer. I do appreciate that clarification. Seeing no further questions, we do really, as always, appreciate your very insightful testimony. Thank you.
Sure. Any way I can help.
Clarissa, is any additional online testimony? Seeing none, I'm going to go ahead and close public testimony. Committee, what's your pleasure? We can certainly delay, take no action now, delay consideration, or we can take it up now, work it, and put it out the door.
Mr. Chairman, the only question is whether we'd want to really wordsmith that last sentence, lines 14 through 16, Senator Nethercott. I don't know if you have any thoughts on whether you want to leave that as it is, or you want to change. Do you have ideas now, or should we do? You're good now. Okay. With that, I'll move.
Bill has been
Yeah, move 24 LSO 0105, Secretary of State expedited filings, working draft 6, 0.6.
Is there a second? Oh, Representative Andrew. Thank you. Excellent. It has been seconded.
All right. I think Senator Nethercott has some thoughts.
I think we've got some amendments teed up. Senator Nethercott.
Thank you, Mr. Chairman. Thank you. Page 2, line 8. We're striking the language of the any document and providing specificity of the type of document, the purpose being related to the corporate filings. So it would be as recommended. Any required document associated with, I think it's the Wyoming Business Corporations Act, Title 17, and then the title of the act of Title 34.
Mr. Hopkinson, does that work for you? Do you need further clarification?
Thank you, Mr. Chairman. So do we want to include just the entirities of Title 17 and 34?
Yes.
Because 17 covers more than just.
Right.
Okay.
Yeah, all of 17 and all of 34.
Co-chair, if we just say, under those filings under Title 34 and Title 17, is that broad language sufficient for you?
It is,
Senator?
Mr. Co-Chairman, and I think LSO can finesse that to make it make sense.
Yeah,
It's a conceptual amendment.
basically make it corporate filings.
Make it
I
make
think
sense.
we all know what we're shooting for here.
Committee members, you've heard the amendment. Is there any further questions or discussion on the amendment? We can call for the question. All those in favor of the amendment, please say aye.
Aye.
Aye. All those opposed say no. That amendment is adopted. You're back in the bill.
And then, Mr. Chairman,
Senator Nethercott.
on line 16, change the timing of filing to the timing of receipt.
Is there a second to that amendment?
Second.
Has been seconded. Committee, any further discussion on the amendment?
Mr.
Questions?
Chairman, my only question
Mr.
is
Co-Chair.
if there is legal receipt might not be the legal term of art elsewhere for whatever the official moment is. And I don't know. It's clearly not filing, which is a bit of a consideration. Mr. Kaufman? may
Mr.
know?
Kaufman?
I'm sorry, I had a comment.
Oh, okay. Yeah, let's dispose of the amendment first.
Mr. Kaufman, do you know what that word of art would be or Mr.
Mr.
Hopkinson?
Crossman's looking it up.
Okay. What is the key word?
Colloquially.
Yeah, we're okay.
Colloquially, I always interpreted them as the same thing, but I want to make sure we get this right.
It's not. It should be.
registration.
It's receipt.
Mr. Crossman, please.
Okay, Mr. Chairman, I haven't found the specific language, but what it does refer to is the effective date. When you're talking about, so I'm attempting to find by that, but the effective date is defined in the statute as the date of receipt or delivery. So
So receipt is consistent.
So receipt.
I believe receipt works. So if a record is delivered to the Secretary of State for filing under this chapter and filed by the Secretary of State, well, that's inaccurate information. Unfortunately, I had written a memo about this, but I did not bring it with me because it was, like 6 months ago, but
Yeah, Mr.
Senator
Chairman,
Scott.
I don't want to overcomplicate things, but I think what we heard was the purpose that a simple expedition of a filing document doesn't create any special benefit. It's just expedites the document in exchange for a fee. Except that it could in fact confer a benefit, which is why you expedite a document. Otherwise, why do you expedite? Because what does expediting a filing get you? The benefit of having filed documents with the Secretary of State's office, which is in fact a benefit. Which is why one expedites. So if that's really the purpose, and Wyoming treats it differently, contrary to every other state, which is something that I think requires maybe a review later with the Corporations Committee. If we're really trying not to do that, it isn't then how fast the Secretary of State's office processes the documents it receives. The benefit in Wyoming attaches at the time the customer provides the office the document and it's stamped immediately, regardless of whether or not those documents have been properly accepted by the office, correct?
yes,
And it's possible that those could be rejected, correct?
yes, absolutely. And if I may, not only may they be rejected at a later date. So to give you a bit of color on how this would happen with a name conflict situation. So as it stands right now, you file your initial filing online. We have rules about the differentiability of names. You cannot pluralize a word and expect it to get past we will reject it. However, there are certain types of manipulations you can do to the language that we would reject, but the computer can't tell when you're filing online. So the person chooses the name, they file the document, they receive basically presumptive authority that their document is good. The next day we check, oh wait, that name isn't valid. We effectively give them 10 days to correct that. And if they do not correct it, their filing is canceled and void ab initio. So yes, while we consider basically it's like in trademark. You file your document, that is the day that it is legally authorized, assuming we process it and accept it. If we do not process it and accept it, you lose that date. So there's a delay between receipt and effective date and final processing, but we are saying that Wyoming does not count that final processing against you for the effective date, assuming you are finally accepted.
Senator Nethercott.
So let's say, for example, you have two entities that file the same day. Competing names. Unlikely, but possible.
Mhm.
One is filed appropriately, one is not. One makes the correction within the 10-day period. Who wins?
So, Mr. Chairman, if I understand your hypothetical correctly, you have two entities file, call it 5 minutes apart.
Mhm.
Entity A, the first to file, files it incorrectly. Entity B files it correctly. There is a name conflict. We then receive the name conflict the next day, process it and say, entity B, you need to correct, or entity A, you need to correct your name. But entity B is technically now live. Actually, we would probably avoid both of those entities in the way I'm envisioning it happening, because they would both be conflicting. And the way we have it, the new system that we have that now catches name conflicts would probably capture both of them. With respect to names, I don't necessarily see people utilizing this expedited filing system, because you get the benefit of just paying it online. But that said, of course, somebody could do this. And in the situation where we had two people fighting over a name like that, we would just default to first in time. We do give people the grace of, if they file it and they correct it, their filing stays live. Where this really comes to play is where you see this very often in our office is if a person or an entity files their annual report, and then by paper, not online, they file their annual report, but between the moment we receive it and the moment we process it, the company goes delinquent and hence would need to be reinstated. And reinstatement costs extra. You have to pay another $100 to get reinstated. However, we received it and we stamped it before it went delinquent. So we reverse the delinquency, process the annual report as of the day we received it, even though we're processing it later, and give them the benefit of having received it on time, even though. So that is where this stamping and receiving thing really you see it commonly in our offices. Those sorts of situations. We don't really see it in other situations as much, mostly because it is actually pretty rare for two people to be simultaneously fighting over the same name.
Mr. Chairman, thank you. I don't disagree.
Senator Nethercott.
I think, clearly I'm the only one concerned about this, but the dispositive effect that occurs in the Secretary of State's office is at the time of receipt, correct?
Mr.
Yes.
Crossman?
Yes, Mr. Chairman, I believe that is correct. So fundamentally, we are a recording office, so we are not depositing with us is not us accepting the document is not proof of the action. It is proof that the action occurred.
Mr. Chairman,
Senator Nethercott.
what is the difference between receipt and a filing?
Mr. Crossman.
So receipt would be the moment we open the mail, and filing is the moment we actually have finished processing the document, making sure that the signature is valid, the money's there, and we scan into the system and affix it with a filing ID number. So filing is effectively the moment we finalize, process, and accept, but receipt is the moment we physically get the document and stamp it.
Senator Nethercott.
Mr. Chairman.
Mr. Co-Chairman.
To assuage Senator Nethercott's concerns, what if we had of filing or receipt, which would mean that it would not affect either the timing of the filing or the timing of the receipt? No preference would be granted. Or would you just prefer receipt? Receipt seems to be a good word now.
Senator Nethercott.
Mr. Chairman, I'll just withdraw the motion and look forward to dealing with this 10 years from now.
That motion has been withdrawn.
Hopefully, be some make work for you.
Committee, any further? Mr. Kaufman, please.
Mr. Chairman, if you'll indulge me, just one addition, since there was a motion made to include specific references to Title 17 and 34. I have a suggestion that we might want to include Title 40 as well for trade names and trademarks, because a lot of times we do corporate filings for mergers in conjunction with trade names, trademarks. I'd hate to exclude that. Thank-
Without objection, let's just do that.
Without objection. Committee, any further consideration?
Mr. Chair.
Mr.
Chairman.
Representative Andrew, please.
Mr. Chairman, I'd like to move that we on page 2, line 5.
Representative Andrew, we've already got a motion that's currently open right
Oh,
now. Yeah. Just any further discussion? Let's go and just do a voice vote. All those in favor of the amendment, please say aye.
Aye.
Aye. All those opposed? The motion amendment is adopted. Representative Andrew, go ahead.
Thank you, Mr. Chairman. I apologize for that. I would move that on page 2, line 5, we increase the maximum $2,000 fee to $5,000 just to kind of future proof it. Because if that's the absolute minimum we would like to look at, that'll probably be insufficient relatively soon. Thank you.
Second.
Motion is made, and seconded. Committee, is there any discussion on the amendment?
Mr. Chairman, I'll have one thing.
Representative Yen.
So my only worry is that it's a budget year and this is easily amendable after it passes the 2/3 introduction vote. However, you know, I think it'll be fine either way, but some people find big numbers kind of scary sometimes.
Representative Yen, I am personally scared of big numbers. So I appreciate that point. Question being called. All those in favor of the amendment, please say aye.
Aye.
All those opposed say no. That amendment is adopted. We're back in the bill. Committee, any further discussion, deliberations on this? Let's go and let's dispose of this measure and do a roll call vote. Clarissa?
Mr. Chairman, this is a roll call vote for 24 LSO 105, Secretary of State expedited filings as amended. Senator Ellis?
Aye.
Senator Furphy?
Aye.
Senator Nethercott? Aye. Representative Andrew?
Aye.
Representative Singh? Representative Yin?
Aye.
Co-Chairman Rothfuss?
Aye.
Chairman Western? 8 ayes, Mr. Chairman.
Fantastic. Next up, we're about an hour behind, but let's go ahead and just take a quick 10-minute break and then we'll move on to amendments to decentralized autonomous organizations. So it's 413. So let's go ahead and just say 420.
Yeah.
Yes. Yeah, David Cheney.
Yeah.
So again, on the point I made about registration, just digital, would that actually be considered valid for securities purposes? So aside of the laws are pretty loose with regards to that, with regards to exempt transactions. I'm used to dealing with SEC and it looks like you guys are also the securities administrator, right? So.
Yeah, I mean, there's no question. I think one of the things that I'm looking at with the language as it was drafted.
No, I get it. I just said that all trust the old USA, Uniform Security Act laws, USA, after it's in little inside of the register, that's all it says, or it's an exempt transaction. So my question is, okay, but is this effectively a backdoor registration? And again, we're not trying to, do anything, that people understand. Well, I was just kind of curious,
Right.
because again, secondary sales are top of mind for us. And so we passed the hurdle at the SEC, and now we're sort of like concerned about blue sky, and what's called manual exemptions, and there's also, you know, like voice registration at the state level. So I'm just curious if this might be a way that things could be registered. Most of those laws are really, they're ineffective anyway, because you would have no way of knowing if there was a 13th sale that happened in the state, right? Because there's no registry of that stuff, right? Secondary sales happen in things like, well, you know, law firms or family, you know, estate sales or whatever. Anyway.
There's a lot of open question, and I think hearing you whisper that to me, my memory, that language is there, and through it, it's there.
If we were gonna do anything, we're trying to do like the fintech sandbox.
Sure.
Route, you know, and get-
That's us too.
And, you know, I know that, that's what I'm saying, we'll work with you to figure that out, like, we want to re-domicile most of our empire out of Minnesota anyway, and our broker deal that we acquired is a Delaware, you know, LLC, so we want to kind of clean all things up and just re-domicile here in Wyoming, and so we absolutely come and ask and work very collaboratively. Just got license runs ATS, and we know that secondary sales are top of mind, like, there's a whole bunch of companies trying to get an ATS, we know the process takes 18 months minimum.
Minimum, 3 years.
So we have a little bit of response.
I was just looking.
Joe can connect you with.
Okay, friends, I'm out.
You guys have cards. I can take
My last card.
Take a picture. I ran out of cards last week.
Here, your phone, just take a picture of David.
My personal.
So I need to.
No, I do.
Oh, great, okay, very good.
I do. Small stack.
Beautiful.
There you go. There you go. Oh. Yeah. We were with some guy at a meeting the other day and he had a QR code. Small.
I have, yeah.
That's
That's
the
the
neat
fun.
thing.
The back of my business card has a QR
Sure, I
code. It's
thought
inside
that
the
was
slab.
pretty slick.
It goes right in my
But,
phone.
you know, particularly guys, just seems like. Yeah.
I thought there was comments that Brandon was making, it's like, look, you can show digital bids on the QR code.
Sure.
Like, that's easy. Like,
Sure.
they're not hidden.
Sure.
All right, folks, it's a nice little break. We've got one last order of business before the committee this afternoon. The short version of this is some of these protocols have been interested in these unincorporated nonprofit statutes, and some of them have expressed interest in Wyoming. Certainly some of the bigger ones, and there's a potential here to help recruit some of those swaps. And so, Mr. Kaufman, I'm going to let you take it from here because this is kind of your baby, and lead the discussion on this one.
Yeah,
If you don't mind
thank
filling us all in, please.
you, Mr. Chairman. So the genesis of this idea was, obviously everyone knows that we created the Wyoming Dow LLC. And the idea behind the structure of that bill was we have existing LLC law to create the Dow LLC as sort of a subtype of the LLC, that if you meet those criteria, right, you can opt into that. What I think we've seen pretty clearly is that in the distributed, decentralized sort of startup world, that works for some entities, but for certain entities that are truly operating at a programmatic level, there isn't really either a desire or an ability for them to create a common sort of, I like to call it a surface point, right, where they can come up to the surface and have the ability to file with Secretary of State, have particular identified members transact, right, in a way that other registered businesses would. So what we've seen, and if you follow kind of the crypto world in general, obviously some people have used foundations, right? Some people go offshore and use different types of nonprofit or foundation type entities. There is sort of this thought amongst some of the kind of protocol level organizations or DAOs that you can utilize something that already exists in statute called the Unincorporated Association Act, which is a uniform act that I don't know if all 50 states have it or not, but it's a uniform act that most states have. Of course, the Unincorporated Association Act is very, very old, right? And doesn't necessarily contemplate a lot of the concepts of something like this. So the aim here is to solve a problem for those types of DAOs and protocol DAOs that don't have the ability to register as an LLC, and that frankly just doesn't fit their business model. This is an alternative so that they can be nonprofit, right? They can still elect to provide their membership with liability protection, to have a point of access to interact with the state, to have a registered agent, right? To purchase property, or any other number of things that an organization would otherwise do. The problem is our existing Unincorporated Association Act doesn't really accommodate that because it's such an old act. These are new concepts. So the bill, and I was apologizing to the chairman a little bit ago about the length of the bill. This is really an attempt to bring new sort of uniform definitional framework to this old structure of entity, not replacing the Unincorporated Association Act, but creating a subtype, right? A new type, just like we did with the LLC. Just for everyone's benefit, we're not the only state looking at this. Texas is looking at something very similar to this. They've been moving much more slowly. But yes, Mr. Chairman, we do believe that there's a large appetite from very large protocol level DAOs who need a home in the United States where they can organize and provide, membership, limited liability, nonprofit status without having to, if they don't want to, formally register a nonprofit corporation, which kind of defeats, right, a lot of those purposes. So that's what this is about. I kind of view it as frankly, a really perfect complement to what we started with the Dow LLC as kind of a for-profit, right, registered entity. And this is kind of the nonprofit unregistered complement to that. So that's the rationale justification for it.
Thank you, Mr. Kaufman. I certainly echo that sentiment that it does fit in line with a lot of the work that this select committee has done over the years, whether it's in regards to Speedy Banks, tokenization, or those other types of efforts, because certainly the guiding ethos of this committee is we want to be business friendly. We want to recruit these tech companies to Wyoming. And I think if there's legislation that we can do, or we can certainly consider to do that very thing, I think it's a good use of the committee's time. David, are you okay presenting from there, I assume?
So, well, Mr. Chairman, I certainly defer to your preference on that. And with respect to this bill, I just wanted to note kind of before, and if you want me to walk through it, happy to do that. But the language of the bill was provided to LSO. It hasn't been through our internal review process, given the timing of when it was provided. So it has not, as published, been reviewed. And going through it when I had a little bit more time following the publication, I do have some concerns about it. I do think I could probably cut about 15 pages. So if it's your preference that I walk through it now, or if I work with Mr. Kaufman and those who drafted the language to kind of try and get it a little bit more polished, and then the committee address it at the next meeting, I defer to you and the committee, but I'm happy to walk through it. Your
Yeah,
preference.
or sorry, go ahead, Mr. Co-Chairman.
Thanks, Mr.
I
Chair.
think we're thinking the same thing here.
Yeah, I think a high level walkthrough at this time, not a detailed one, because I do agree. I know that it hasn't been through the process and that we'll definitely be looking to the next meeting to finalize this, but just for the sake of those listening and you know, those tuning in to understand what it does as a walkthrough so that we can be seeking the feedback that we typically like to get ahead of the next meeting from stakeholders that might have interest so that they can weigh in. I think that would be beneficial, but I don't think we need to go into it in fine detail. So if we can get sort of that mid-level walkthrough so that the committee understands and the public understands what the intent of the legislation is, and then we'll go through the process of thinning it by 15 pages or so and running it through the system and end up with a good bill when we come back in November. Does that sound good, Mr. Chairman?
Mr. Co-Chair, I would largely agree. I think, it's well up to 4:30 right now. We still have plenty of time that we budgeted. So I think kind of a high level walkthrough would probably be beneficial, but ultimately I think let's not take any action on this right now. Let David, give him some time to work through it, trim it up some, and then we can come back with a more refined product here in November. That's certainly my thought, but you can go ahead from where you're at, David, and kind of just walk us through it at a high level.
Certainly, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through 24 LSO 104, working draft 0.3. So the draft creates a number of new articles and a new chapter in Wyoming Statute 17. It would create a new chapter 32 and new articles 101 through 130. 101 there is just a short title, the Wyoming Decentralized Unincorporated Nonprofit Association Act. 102 provides a definition of a number of terms that are used throughout the act. A number of those are just to highlight it. I think a couple of important ones there. You've got the term of administrator, the person authorized by the members to fulfill those operational tasks. That you see that throughout the bill. Specifies what a charitable purpose is. Specifies what a decentralized unincorporated nonprofit association means. And some of those definitions there on page 3, you see that it's consisting of at least 100 members joined by mutual consent under agreement. It may be in writing or inferred from conduct. It has to be elected and formed under this chapter, and it's not formed under any other law governing the association's organization or operation. See a definition there for digital asset, which is just what's already in statute. And then just kind of skim through them, next few pages, additional definitions. On page 6 in Article 103, the governing law, and that provides that the law of the state governs any decentralized unincorporated nonprofit association formed in this state, and that those governing principles must identify the jurisdiction in which it is formed. And 104 provides over on page 7 that I apologize. I'm just spending a moment thinking of an acronym for Decentralized Unincorporated Nonprofit Association instead of having to say it each time, but DUNA, is that what we'll use? All right, DUNA. That'll save me some time. So that they may engage in profit-making activities, but they must be used in furtherance of the association's common nonprofit purpose. That the DUNA may not pay dividends or distribute any part of its income to its members or administrators. Provides that Aduna may pay reasonable compensation or reimburse expenses to members and administrators, etc. It may confer benefits on its members in conformity with its nonprofit purpose. It may repurchase membership interests to the extent of its governing principles. It may make distribution of property to members upon winding up to the extent permitted by 126, which we'll get to. We're on page 9 now. Article 105 provides that the DUNA may acquire, hold and encumber or transfer an estate or interest in real or personal property, and that it may be a legatee, devisee, or beneficiary of a trust or contract. 106 requires a statement of authority as to real property, and that they shall execute and record a statement of authority to transfer an interest in the estate or in real property in the name of the DUNA. And it may be transferred by a person authorized to do so by that statement of authority. Subsection C on page 10 requires or sets forth what a statement of authority shall include, and it should include the name of the DUNA, its address, including street address, the name or title of the person authorized to transfer the estate or interest, the action, procedure, or vote of the DUNA associated, which authorizes the person to transfer that interest. And then the statement of authority shall be executed in the same manner as a deed. The filing officer may collect a fee for collecting or recording the statement of authority in the amount authorized for recording a transfer of real property. And an amendment, including cancellation of a statement of authority, shall meet the requirements for execution and recording of an original statement. We're over on page 12. If the record title to the real property is in the name of the DUNA, and the statement of authority is recorded in the office of the county clerk, the authority of the person named in a statement of authority is conclusive in favor of a transferee who gives value without notice that the person named in the statement of authority lacks authority. So that's now down to Article 107, liability and tort or contract on page 12. A DUNA is a separate legal entity from its members for purposes of determining and enforcing rights and liabilities in contract and tort. B provides that the person is not liable for a breach of a DUNA association's contract merely because they are a member authorized to participate in management, etc. On page 13, C provides that the person is not liable for a tortious act or omission for which the DUNA is liable merely because they are a member or administrator, etc. A tortious act or omission of a member, administrator, or other person for which the DUNA is liable is not imputed to a person merely because the person is a member of the DUNA. Down in E, a member, administrator, person authorized to participate in the management of the affairs of the nonprofit association may assert a claim against the DUNA. And a DUNA may assert a claim against a member, administrator, etc. Or a person considered as a member by the nonprofit association. So that's just indicating those claims can be made going either way. 108 on page 14. A DUNA in its name may institute, defend, intervene, or participate in judicial, administrative, or other government proceedings. A DUNA may assert a claim on behalf of its members if one or more members of the DUNA have standing to assert a claim in their own right. The interests the nonprofit association seeks to protect are germane to its purposes, and neither the claim asserted nor the relief requested requires the participation of the member. In 109, a judgment against the DUNA is not by itself a judgment against a member or an administrator. 110, a DUNA may file in the office of the Secretary of State a statement appointing an agent authorized to receive service of process. And then the rest of that section details with what that statement appointing the agent shall include. And how it's signed. It details the filing fee and how amendments are made and what happens if the Secretary of State refuses to file that document. On 17-111, in an action proceeding against Aduna, a summons and complaint shall be served on an agent authorized by appointment to receive service of process. And if none of them can be served, then it's maybe made on a member. A claim for relief against Aduna does not abate merely because of a change in members or persons authorized to administer its affairs. On page 18, 113 for venue. For the purposes of venue, Aduna is a resident of the county in which it has an office, or the association has appointed an agent for service of process. 114, Aduna has perpetual duration unless its governing principles determine otherwise, and Aduna may be dissolved through any of the following methods. It's which include there's a set time for dissolution, or if the governing principles do not provide a method for dissolution, then the approval of its members would provide for that. Or if the membership in the nonprofit falls below 100 and the Aduna does not meet the requirements of the existing Wyoming unincorporated nonprofit association under those statutes. If that membership does fall below 100, the entity automatically converts to an unincorporated nonprofit association unless the governing principles otherwise specify, or may be dissolved by court order. And then after dissolution, Aduna continues in existence until its activities have been wound up. On page 20, we're halfway. Am I going too slow or too fast or too slow? Okay, I'll speed things up. Should I just talk faster? Will that? No.
Mr. Chairman, maybe fly up like 10,000.
Okay,
We're at 10,000. Let's get to 20.
We'll move it up. We'll higher overview here. Okay, on page 20, Article 115 specifies how a person may become a member and what governing principles that they apply to them, and how a member may be suspended, dismissed, or expelled. And 116 discusses or specifies how a member may resign from an association and what interests they may have or have to give up to do so, and provides for that. 117 provides for the duties of the members and what obligations that they have, fiduciary and otherwise. 118 provides that a member is not an agent of the Aduna solely because they are a member, and that their status as a member does not restrict other law, either from this chapter or other laws from imposing liability on Aduna because of a person's conduct. 119 provides for the transferability of the interests of the member and how that can take place. 120 provides for the voting kind of process that the members may have, and the majority vote in dealing with other members and other processes that would be typical to a nonprofit association, and the actions that they would take. Page 25, 121 discusses or provides for the utilization of blockchain technology or distributed ledger technology, and how that would integrate with the Aduna. 122 provides for the governance in accordance with the governing principles, provides that it can adopt algorithmic means for governance, etc. 123 provides a process for the selection of administrators of the Aduna, and the requirements or lack thereof of how that would play out, and what they need to do to provide that, is including things like duties of loyalty, breach of loyalty, etc., and why an administrator may be suspended or removed. 124 provides a right of members to inspect records and the process on how to do that, and when there's obligations on either side for the inspection of those records. 125 provides for the indemnification of administrators, and insurance, indemnification of members, et cetera, depending on a variety of circumstances. And when those might apply. 126 deals with the windup and the termination of it and how it can be dissolved and the process it has to go to and what it has to abide by there. Over on page 36, 127 just deals with the mergers. There's a bunch of definitions there on how that works out and what happens in a merger, what's required to merge and what's required of the surviving organization. That gets us through 45. 128 provides for the conversion and the application of existing law on how it might convert from a DUNA. At 129 just provides for the kind of uniformity and severability of law in there, and as does 130, which is actually in there but wasn't formatted properly. Section 2 provides that the principles of law and equity supplement this act, and it would be effective July 1st, 2024. And with that, I'm happy to answer any questions.
Thank you, David. Mr. Co-Chairman.
Thanks. And one thing I wanted to emphasize that I know as we move to the next draft is that most of the provisions, or a substantial portion of the provisions, are based on the assumption that they're default positions, as I understand it. So if the articles of incorporation or articles of agreement are contrary to this, there's still broad flexibility, as we did with the Dow LLC. I believe that's correct. And I think that's an important part of this based on feedback we heard from the Dow LLC. Any other themes along those lines that we should be communicating or at least be focused on, Mr. Kaufman?
Mr. Kaufman, go ahead.
Yeah, Mr. Chairman, I don't think so. I think those are it. I mean, we obviously made a conscious policy decision with the Dow LLC to trade off, right, for allowing these types of entities to register by requiring just a little bit more transparency than we might with other entities. And I think the same analogy is true here. There's a few thresholds. This isn't just going to be available, right, to anybody. You have to meet these certain criteria, but also with that comes some requirements or default rules with respect to things like unwinding, right, and dissolution, which quite frankly don't really exist in the same way in other laws. So I do think it's really additive in that sense.
Thank you, Mr. Kaufman. Committee members, any other comments or questions? Seeing none, absent objection, we're going to delay further consideration. But if there's anybody here in the audience who does want to do public comment, we're more than welcome to come up and testify. Mr. Stokes.
Hi, Jonathan Stokes.
Please go
yes,
ahead.
This testimony, I guess, is in reference to Space Ranch Dow LLC and kind of adjacent to the whole Dow topic in general, not specific to the nonprofit aspect. In 2019, I won the Economic Impact Award for our proof case at Dow LLC during the hackathon. What that entailed us winning an office space at the WTBC building a couple blocks away. And through the entrepreneurial journey of trying to bridge the space industry into Wyoming and trying to figure out how to make DAOs effective and functional, I ran into a lot of hurdles and pain points, and essentially pivoted to focus on developing DAO tooling to make an organization such as Space Ranch possible. Through that process, I was able to raise a grant, a $25,000 grant from the Near Foundation. And at that point, this is a process between last August and November, I guess December. And when we were getting ready to get the money, I was really excited to take advantage of the office opportunity. And I guess office politics that didn't happen. So I wasn't able to deploy that capital to bring a bunch of interns in-house into the building and fulfill that building's intended purpose. Instead, what happened, I got gatekeepered and essentially pushed out of the startup ecosystem here. And I went back to Texas. I didn't deploy that capital in Wyoming. That money didn't go to interns that could have helped the project go a lot further. Instead, just went to expensive developers. But I did get an MVP out of it. You go to pigeon.cx. It's an open source peer-to-peer communications. Y'all could start using that instead of Zoom because it's more secure and your data won't get extracted. So I want to be solution oriented with all my points of contention. There's some pain points that, like this, startup ecosystem could be a lot more healthier if there was talent hired into managing the facilities or processes or whatever. I feel like the people are in those roles right now aren't necessarily meeting expectations. And then a second follow-up point is I think there could be some resource allocation to the SBIR department, maybe make some like grant writers available to businesses trying to both start up, but also access opportunities in emerging technologies. So just want to kind of back a little bit. This Web3 space, I think, presents an interesting opportunity for not just Wyoming, but in general to access other adjacent deep technologies like I referenced space. Also, quantum, artificial intelligence, all these other emerging deep technologies that can ultimately be intersected with Web3. So as we discuss opportunities in Web3, we should also be thinking of accessing adjacent opportunities. So the final point I want to get to is to recognize the opportunity that the federal government is trying to make available for emerging technologies through the Department of Defense. I'd like to share some sources with Matthew Kaufman real quick. And these are real legitimate sources and the pathways of funding are available. I want to position myself as a conduit for this pathway of funding and create a potential role and opportunity for me to help facilitate the deep technology development in the state. So that's my ramble.
Thank you, Mr. Stokes. Mr. Co-Chair.
Thank you, Mr. Chairman. I was wondering if you were familiar with the SBIR Phase 0 program that Wyoming has so that you can have assistance from the state to develop SBIR proposals. Is that something you're familiar with?
I'm not familiar.
Mr. Stokes, go ahead, please.
Oh, thanks. I'm not familiar. I tried to navigate the SBIR within the university system here, and I couldn't bridge that gap of communication. So that's why I'm thinking that maybe they need more resources in their department to, as the startup ecosystem grows in Wyoming, then they could, meet the demand.
Excellent. Thank you. Appreciate that. If follow up with me and I'll try and connect you with that Phase 0 program, which sounds like it wasn't very well marketed or communicated. It should be doing some of what you're looking for, but might not be perfect.
Okay, thanks.
Thank you.
Mr. Stokes, if you would mind, just have a seat again, make sure that no one else has further questions for you. The committee, any further questions for Mr. Stokes? Seeing none. I think we're going to go to, is there anybody else in the room who want to testify on this? I think we've got some folks in Zoom land. I think Brendan. Brendan, can you hear us? Take it away. Floor is yours.
Oh, great. You all can hear me, right? Yep.
We can.
Okay, yeah. Brendan Marr here. I introduced myself before. I will add that I have also been on the working groups for the Dow working group for the initial Dow based on LLC statute and supplement. So I want to say first off, yes, I think it's a tremendous step forward. And I would like to provide some broader context in terms of, why we're doing this, and make a small comment regarding the bill draft and state that, I hope to make some, additional comments if we're going to roll this into November that might be useful for the other working group members. So the broader picture, like why are we doing this, is important. And I think it's much more important than one might think, because it's not just about this idea of DAOs as we currently know them. I fundamentally believe that this new form of organization is going to be such that, every corporation, a Coke, Louis Vuitton, whatever, they're all going to need these kinds of DAO entities, which allow them to work with their consumer base in a very different way, right? They become the extension of the brand in a way in which the brand gets to do novel and interesting things under the charter of the brand, but in novel ways. And I think this is just tremendous. What this solves from a statute standpoint is the pegging problem, which is, how do you allow for these DAOs to contract, right? Make legal contracts and do anything that is needed to peg to a jurisdiction. And if we're going to do any useful stuff, we really need to put something like this forward. And it also solves the problem that the DAOs, which are based on the Koala model, which are a little more focused on European law, and the spinoff of this, which was the Utah DAO, it allows to solve things that are a little bit more straightforward than those statutes. So I think it's great. I think we're going to have to tweak some things. One thing I'll throw out there right at this point, which is a minor tweak, is this idea that if it drops below 100 members, that it instantly implodes. That's fine. I would probably add a time component, because you might have the situation where what if it's just like near 1,000 members, and you have, it's 100 members, and you have 105 members and 5 members rage quit in the month, right? Does it instantly implode? Well, maybe that doesn't make sense. Like, what if they, drop out for 2 hours, and then all of a sudden the numbers get bumped up to 125 members, right? Like later on in the month. So having a time component there would be useful. I'll take questions. I hope that's helpful.
Thank you, Mr. Maher. Mr. Co-Chairman.
Yeah, and that's an interesting point about that membership. I don't know how that triggers. I think that's something we definitely have to look into. Mr. Kaufman, how would that trigger as far as this loss of membership that Brennan's talking about, where you have a circumstance where you have an appropriate membership, and then as he pointed out, the possibility of you've got half of them that rage quit one day, that potentially makes them ineligible to file. But is that a dissolution moment as drafted, or how would that work?
Yeah, Mr. Chairman, that's a good question. I'm not sure that I have a specific response to that, because this act is designed to be, it functions just a little differently than a traditional corporation, right? Because it's allowing fluidity with respect to your existence, right? Based on you meeting these criteria. So, the idea behind that 100 members minimum was just kind of some industry commentary that you need for an unincorporated entity like this. You need some certain amount to achieve sufficient decentralization to be able to call it a DAO and to have that, on-chain governance, et cetera. So that's where that number came from. It's could be defined, but I think Mr. Maurer's point is well taken. Maybe we could look at some ways to create flexibility on that point. So, yeah.
Members, any further questions for Mr. Meyer? Seeing none. Brendan, was there any other concluding remarks you wanted to make?
No, not at this time, but I hope to contribute over this month to small tweaks.
Please do stay involved. And if you have further testimony on this specific one, you're welcome to put an email form and send it to the committee so we for further review.
Sure, great. Yep, thank you.
Is there anybody else in the Zoom world? Let's bring him in. Mr. Kirk, can you hear us?
Indeed, yes. Can you hear me?
We got you. Go ahead. Floors, please introduce yourself and who you're with.
Thank you, Mr. Commissioner. My name's David Kerr. I have my own consulting agency called Cowrie. Through Cowrie, I write a lot of publications in entity structuring, taxation, and planning for decentralized organizations with my co-author, Miles Jennings, who's the general counsel for A16Z. He had to fall off the call just given how long it had ran. But I stayed on, just kind of check base on a few points. We've kind of written a series of papers about the need for the continuation of the nonprofit, how it intersects with the existing laws, the Dow laws around the LLCs, and why this is kind of a natural evolution that supports a lot of the larger protocols. And so that's kind of one of the areas I think will be of interest to Wyoming as this process continues, is that he'll make a commitment to make a letter on behalf of A16Z, and we'll bring in probably 40, maybe more, of some of the larger projects to kind of in support of this bill and for the reasons why. Sorry, I drafted most of it along with Miles and then submitted it through Matt Kaufman. We've done a similar bill for Texas, and then a kind of a very different but similar in the sense that it's both based off of the UNA for California. They've passed through committees. The Texas one passed through the House, but at this time, there's still ongoing legislations. They were not finalized in this last legislative session. And Wyoming is just a great fit for expansion of the Unincorporated Nonprofit Association, because like in all things, the first state to adopt the Uniform UNA Act was Wyoming. They did it in 1993. They were about 3-4 years ahead of the next adopting, and they paved a lot of the way for how the UNA came into existence and really kind of resolved some of the issues around unincorporated associations under the common law. And so the reason for the length of this bill, and I'm very happy to work with David and Brandon, and anyone else who has questions, I can be reached through Matt Kaufman very easily. I love talking about all of this in detail. About a third of the bill, the first third, is almost identical to the Unincorporated Nonprofit Association Act in Wyoming currently. The only changes are the addition of the 100 members and the bringing forward of the concept of administrators, which is, kind of a substitute for managers. You still need a real world presence to sign contracts, and it has to happen at the express will of the organization. So that concept is kind of where it differs from the UNA primarily. The Wyoming UNA is very minimal in construction. It was a default statute to provide these protections to a number of entities, whether they were, charitable in purpose, religious in purpose, small, big, informal organizations on their way to becoming nonprofit corporations, co-ops. So there was a lot of different kind of groups to speak to. And so for that purpose, the internal rules of governance was not particularly defined in those early adopted UNA statutes. And the reason for that is they spoke to too many different entity forms. By placing a strict prohibition on income, and by making a couple more just tailoring of who can use the statute, that's where the ability to speak to the internal governance comes from. It'd be very easy to cut about 15 of the sections, so half of the sections could be cut and just default to the governing principles. The reason behind their existence at this point is there's just a lot of confusion in this space on how to use these laws, understanding the background. And so by providing this kind of this the scaling, this basic framework. We're hoping that, we provide a path so people can use these laws a little more smartly and not be left having to figure it out on their own, or maybe doing things that are ultimately improper. And so the length in a lot of ways comes from making sure we hit every issue with kind of full accounting and then tie it back to existing Wyoming law. And I'm happy to take that into next session and the work we do in between to kind of make this more in line with the type of bill you're interested in passing.
Thank you, Mr. Kerr. I don't know if you caught some of the dialogue, but I think given where it's at right now, we're probably just going to not take any action on it at this meeting. Let LSO and David just refine it and get it to where it's more ready for prime time and take it up for further consideration at our November meeting. And I certainly hope that you'll be able to zoom in during that meeting as well to give input and help us in coming up with the finished product. Mr. Co-Chair, were you going to say something?
No, Mr. Chairman, that was basically what I was going to say is we appreciate your involvement and the work that you've done for this and hope to keep you a part of the process as we move towards that November meeting with an updated draft that is more consistent with what you just laid out, where we can cut out some of the sections based on the default language falling back to what existing Wyoming statute, and then make sure that it's compliant with Wyoming statute. The other aspect that I don't think is in there is, and probably a separate section of law, just clarification about Chancery Court access. I don't know if we need to have any inclusions there or not. That might already be applied, but just seeing what else needs to fit in with our existing statute, similar to what we did anywhere other tie-ins for the Dow LLC Act would be something to consider. But appreciate your involvement and all the hard work that you put into this. One thing I will ask is, I think it's important for us to contemplate any pushback or concerns that are out there. If this has been discussed in other states, is there anything that we should be wary of or thoughtful of, or any other solutions that we need to be looking for that might be concerns we should be contemplating?
Mr. Kerr, go ahead.
Yes, thank you, Chairman. So there's really two. One, the UNA itself is not a particularly understood act, and it represented a very sticky point in common law where these kind of organizations were treated more or less like general partnerships under the aggregate theory. And it was, a lot of states, a lot of different municipalities and governments over cross jurisdictions took the stand that was very unfair to the individuals involved in them. And some of the states are very pro that, that's the way that it should be, that the original common law. So there is a bit of a division on the UNA itself. In the case of Wyoming, Wyoming is very clear that it was the first adopter of the UNA. And so I think that kind of pushback would be less common. But I can say with experience going before California, when we brought our proposed bill before California, we took a lot of heat in the hearing over what existing California law has allowed for the past 22 years. And so there are elements of this bill that I think a lot of individuals do not like. I would also argue that those have been existing Wyoming law for 30 years. And so I think getting that educational process together is really important. And then kind of the second thing that some individuals are not huge fans of, and this is more came up when we presented to the American Bar Association, and we had some of the folks who drafted these uniform acts weigh in. There is quite a bit of criticism around how the transfer of property can ultimately lead to, bringing it outside of the nonprofit structure. And I think that's also kind of a confusion. If you apply for tax exemption at the federal level, then that does place limitations on your ability to become a for-profit entity down the road. If you do not, if you just exist as a nonprofit, then you are paying tax at the federal level, you're meeting all of your compliance, you're not getting a benefit, and you're not putting yourself out to the public as a religious organization or a public charity. And so I think the same level of public concern that a legislature might have for protecting its citizens doesn't necessarily apply. And that's why there's that definition for charitable purpose at the very beginning. There are elements of this law that can adopt that kind of form where there would be really strong public policy purpose for limiting how these organizations could be utilized. Because once you've presented yourself as religious or public benefit or as a charity, then continuing that's important. On the nonprofit side, I think it's a lot less so because they haven't made themselves out to be tax exempt. They haven't received any benefits from it. And so I think that's a larger conversation that will probably come up over the course of, the history around, discussing this proposed chapter.
Mr. Co-Chairman.
Thank you. And it's my understanding on that aspect also, that would be largely legacy statute. And I didn't go back and compare it to the existing definition in the Wyoming UNA statute, but I assume that in the nonprofit.
It's identical.
section there,
Yes, sir.
it's
It's identical. Yeah.
That's what I assume. So that's not new ground so much as the fact that in the cases you've seen, legislators weren't even aware that that was on the books, and now they have concerns about legacy statute. Is that fair, or is there something new about the Dow implementation that is leading to more concern in that space?
Mr. Kerr, go ahead.
Thank you, Chair. No, nothing new. I would say that there's a couple parts at the end where we get into merger, we get into windup, and windup's really essential. I don't think under any terms can we take that out, because you have this decentralized entity that then fails, and it needs to figure out who's in charge of winding up it responsibly. And that's, it can succeed decentralized, but it's going to fail centralized. And so those components are important. I think the merger is something that, should also be considered in regard to the existing UNA and to the Dow law, the insert at Wyoming, and this law. And it should be consistent kind of amongst those three, maybe, whether they want to become more in line with the other entity forms in Wyoming, or whether there's a reason to expressly prohibit merger. I think there's a couple of ideas that are probably worth considering. The language provided is how it would work if it should work. I think some of the ideas raised may not be what Wyoming wants for the law to do. And so removing them would be something more of a matter of a judgment call than a technical application. But I think there are a few points in it that, do raise, why is this entity form treated differently than the others? And should we find a way to make them all consistent when dealing with DAOs in general?
Thank you, Mr. Kerr. Committee members, any further questions? I will certainly save mine until November when it's a finished product. With that, Kerr, again, we thank you very much for your time and your testimony. Please do stay in touch, and if you're available, we'd love to have you attend our November meeting as well. Clarissa, is anybody else? Zoom world, okay. I believe that concludes our business for day one. Mr. Co-Chair, before we recess, is there any other business or topics we need to bring up?
I think we're good, Mr. Chairman, other than if there's anything that David or Clarissa need from us, any information at this time.
Mr. Chairman, I think we're good.
Good. I don't know if anyone on the committee has any announcements.
The committee members, any announcements?
Excellent.
Well, with that, we are in recess until tomorrow morning at 8:30. I'll see you all back
Thanks
here.
everyone for being here.
Thank you.
Appreciate it.